Good morning and welcome to the District of Columbia Court of Appeals. The court is sitting en banc today. However, Judge Roy McLeese is recused and so will not be participating in this argument today. I'm joined today by my colleagues, starting from the right, Associate Judge Schenker, Associate Judge Deal, Associate Judge Beckwith, and on my left, Associate Judge Easterly and Associate Judge Howard. And I am Chief Judge Anna Blackburn-Rigsby, and it's my pleasure to welcome you all here. We're sitting en banc today in the matter of Glenn Arthur Smith Jr. versus United States. This court granted rehearing en banc in this case to consider the denial of Mr. Smith's Batson challenge. Appellant was charged by indictment with 2 counts of first-degree sexual assault and related charges, and the case proceeded to a jury trial. During the jury selection, defense counsel raised a Batson challenge, contending that the government used its peremptory strikes to strike all non-white prospective jurors, leaving an all-white jury. The trial court denied the challenge, ruling that the government did not make the strikes based on race, and found appellant guilty on both counts of first-degree sexual assault. And after the trial, appellant filed a motion for a new trial alleging that counsel provided ineffective assistance of counsel. Previously, a 3-judge panel of this court heard the case, and the division affirmed the appellant's convictions, holding that the trial court did not clearly err in crediting the government's stated race-neutral reasons for the peremptory challenges at issue. The division concluded that the trial court gave adequate scrutiny, and the division affirmed the court's denial of appellant's motion for a new trial. This court granted the petition for rehearing en banc, solely focusing on the Batson issue below. We also granted the parties' motions for the DC Public Defender Service and the NAACP Legal Defense and Educational Fund to file amicus briefs, and they will be participating in argument today. Each side has been granted 45 minutes. Appellant has agreed to divide its time, providing 17.5 minutes of its time to PDS and 10 minutes of its time to Legal Defense Fund. And the government will argue using their 45-minute allotted time. So with that, I guess Ms. Schneider, Ms. Murphy, could you let me know and clarify the order of argument by appellants? I assume Mr. Day will go first, and then.
We decided that he is.
All right. Ms. Schneider, are you ready?
May it please the court, Stephanie Schneider on behalf of Amicus Curiae Public Defender Service. I'd like to reserve 2 minutes for rebuttal. The analysis in this case must begin with Supreme Court precedent. Miller L., Snyder, Foster, and Flowers hold that step 3 of the Batson inquiry requires the trial judge to rigorously scrutinize the proffered race-neutral reasons for a strike in light of all the facts and circumstances, irrespective of whether they were explicitly pressed by trial counsel. In each case, the Supreme Court conducted an independent review of the record, and it relied on evidence of pretext not argued below, in holding that the judge's credibility findings were clearly erroneous. The government fails to grapple with this binding precedent. When Batson is properly applied, reversal is required for 2 reasons. First, the judge's inquiry was insufficient. He summarily credited the prosecutor's proffer that she struck 3 Black jurors because she was concerned that a plumber's assistant and cashier would not understand the scientific evidence, and because the mechanic misunderstood a lengthy voir dire question. The judge failed to probe these rationales to see if they withstood scrutiny in a racially charged rape case where the prosecutor struck 4 out of 4 Black jurors, 6 out of 6 jurors of color. The prosecutor asked no questions about the science proficiency of any juror. She failed to apply her purported preference for white-collar jurors to a white nanny. She struck a highly educated Black juror an Hispanic juror who
Ms.
had no
Schneider?
yes answers.
Ms. Schneider, if I know it's hard to tell where the voice is coming from when you're standing there. If I could just briefly interrupt you to ask, one of the government's contentions at trial and to some extent on appeal was that, some of the lower court federal cases and some of the cases from this court place some onus on the part of defense counsel to square up, raise up some of these issues, to focus in some way the trial judge on them. Maybe not in the same, understanding that there is a different and additional burden when we're looking at the Equal Protection Clause, which underlies the Batson rationale. How do we balance, how much the trial judge has to do, what, if anything, is on the onus of defense counsel, and whether enough was done to preserve some of these challenges in the record here?
Sure. Well, I think this court has to look at the Supreme Court cases. This is a judicially created test to ferret out racial discrimination. And what the Supreme Court has held in fashioning this test is that appellate review is not limited to the factual arguments advanced by trial counsel. And that's because the entire record of voir dire is in evidence before the trial judge. And they specifically address this in Miller
Do you
L.
think any of our court's prior precedents are in conflict with some of the Supreme Court cases? And if
Yeah.
so, as you answer the question, can you highlight those for us?
Yes. So, in Nelson, which was the case in 1994, and this was a case that preceded, Miller L. and Snyder, that case suggested, right, that a defendant does not meet its burden under Batson, and that this court will not reverse as clearly erroneous a credibility finding if the defense counsel makes, conclusory arguments. So Nelson said that, and understandably, that was before the Supreme Court had really weighed in on what the step 3 analysis is. And it did that in Miller L. and Snyder and Foster and Flowers. But I think what has happened is because Nelson existed, that case has been quoted, and then it's been quoted in a case called Walker. It's been quoted in 2009, a case called Smith in 2009, Brown in 2015, Williams in 2024. And I think what's happened is that notion has just erroneously persisted in the case law. And what the Supreme Court has now clarified is that the entire voir dire is in evidence before the judge. And I think it's important that in Miller L. in footnote 2, they explicitly reject Thomas's dissent. And what he is saying is that the court shouldn't be considering this evidence that wasn't raised. In Miller L., it's a case where the Supreme Court reverses and they find a credibility finding clearly erroneous based on the side-by-side comparisons of stricken Black and accepted white jurors, the prosecutor's disparate questioning, the prosecutor's use of the jury shuffle, and none of that was argued below.
Do you have anything from the Supreme Court where the court is actually addressing what defense counsel has to put forward as opposed to, are we mostly drawing your conclusions here from what the court did rather than what it said?
Sure. Well, I think it's both. I think in Miller L., in that footnote 2 I was referencing, the court says there can be no question that the transcript of voir dire on which Miller L. bases his arguments and on which we base our result was before the state courts. Like the idea that that's before it. The Supreme Court has also repeatedly said that in criminal trials, trial judges possess the primary responsibility to enforce Batson and prevent racial discrimination from seeping into the jury selection process. And then we see them applying these two principles again and again. So I talked about Miller L., but then in Snyder, the court is very explicitly considering a retrospective side-by-side comparison of jurors. And it's very clear that, they say it's retrospective, they say it wasn't argued below. Justice Thomas is complaining about that, and he does not think that is what the court should be doing, but he has the losing argument. They do it and they rely heavily on that in finding that the credibility finding was clearly erroneous.
Counsel, sorry, I see your point about sort of legal notions of preservation and what's in the record for the trial court and burdens, and we can talk about that. But at a practical level, I think that's where it gets a little difficult. So we have fast-moving jury selection, perhaps very fast in this case, but in all cases, it's fast. Trial judges understandably have concerns about losing the jurors veneer that's before them and starting over. What role does the sort of, I mean, don't we have to think about which party is best positioned to raise certain points before the trial court? I mean, the trial court probably doesn't remember that X juror was similarly situated, but the, defense counsel is really the party or the entity that's best situated to keep those notes, to remember those things and to raise them. So I understand the legal arguments, but at what level do we fault trial courts for failing to make those connections if they're not brought to the trial court's attention?
Well, we think that what the Supreme Court is saying is that judges have to scrutinize these factors. And what needs to happen is they just need to slow things down, right? So if it's the rare case, right, where you have a Batson challenge and you make it to step 3. But when that happens, they do need to, put on the brakes and ask some questions. So right in this case, what they could have done is they could have just sent that jury, that whole panel to lunch, and they could have delved into this. The judge could have asked the prosecutor, why does scientific learning matter, right? If we spent all morning talking about how this is a consent case, and we spent all morning talking about how the DNA was uncontested. They could have said, okay, so this is based on profession. Let's just figure out what the professions are of of the stricken jurors and of the seated jurors. I mean, I don't think that's too much to ask in a case like this where we have all the benefits of technology. This is being recorded by the Blue Man. We can ask the court reporter to read things back from the transcript. And this is a really important right at stake. I mean, I think what the court has said time and again is this is about the defendant's right. This is about the rights of the wrongly excluded juror. And what's also at stake is just society's confidence in criminal justice. So taking that pause to ask these questions, to go back to the transcript where necessary, to look at the judge's notes,
Can I ask what
Sorry, go ahead.
about what the transcript shows? Is the trial court even aware of who struck which jurors? I mean, it seems to me from what I can tell from the transcript, aside from the Batson challenge where the trial court is being told, the prosecution has struck every person of color on the jury. Does the trial court even have, and I get one answer might be they could get it. But from what I can tell, they're kind of passing a sheet back and forth, government strikes, defense strikes, government strikes, defense strikes. And so the trial court wouldn't even know if they were comparators that sort of made the Batson challenge stronger. You say that you struck people because of a lack of education, but in fact, you left some people on the jury with the same seeming lack of education. Do you know, did the trial court know about who struck who outside of the Batson challenge?
So as a factual matter, I don't know. I agree that it seems as though they are passing this one piece of paper back and forth. I do think that once, we've made it to step 3, it isn't, incumbent on the judge to look, and to inquire. And the Supreme Court is holding judges to that standard because it's reversing when they don't do that. It's reversing when the judges just say, okay, that sounds plausible, and they don't look at the whole context of the case and they deny the Batson challenge. So I do think that the judge, if he didn't have it before him, and I don't know for sure if he did, this is a time where you put the brakes on, ask the questions, do the probing. I mean, that's kind of what rigorous scrutiny is. You've got to stop and ask some questions.
Well, the trial judge stopped to ask some questions here with respect to one of the jurors pressing the government, and I forget which juror number this was, but it was one of the jurors. And the explanation that the government offered was that they wanted to seat another juror that they thought was more favorable. And by striking the one juror, that would place this other more desirable juror in the box. Well, it turns out we learned after the fact that that was an incorrect assumption because the desirable juror was already in the box. And then the trial judge probes a little bit on a second juror who the government alleged some concerns about that juror's intellect based on their employment as a plumber, but also based on their response to a question that didn't seem to be an appropriate response to the question or indicated lack of understanding. So there was some arguably probing done here. There was none done of the 2 other Black jurors that were stricken. What do we make of what was done here.
Well, I think that the probing of that black alternate about, why did you strike this, marketing IT professional sort of shows what the value of probing is. I mean, that strike didn't really hold up. Once the prosecutor was addressing it, she withdrew it. And I think that's kind of one of the points, is that a judge's credibility finding, if it's based just on the attorney's proffering a race neutral reason, which is what step 2 is, if it's based on just saying, oh, they said it with a straight face, we're moving on, it doesn't really tell us that much, because it hasn't been pressure tested. It hasn't been pressure tested to see how it holds up under questioning. Now, with respect to the other jurors, there was a little bit of discussion about the mechanic. That was the juror who misunderstood the question. But with respect to the cashier and the plumber's assistant, there was no questions whatsoever other than to confirm what their professions were. But there was no inquiry as to, why does science matter in a case like this where DNA is not contested? Did you, prosecutor, did you ask other jurors about what their scientific backgrounds were? If the answer is no, why not? Did you apply this this criteria to all the jurors? Like, let's look and see. There was none of that to see if it holds up.
You were talking about mentioning the trial judge's crediting of the reason, but it's really hard to understand what that means in this case, because it looks to me like the reason that's being stated, the judge is just acknowledging it as a legit reason, something akin to what the government says the defense concedes, basically. Is it your view? I mean, you've been talking about it as a credibility statement, a statement judging credibility, but is it really that? It almost seems like it doesn't quite move to that point. It's just saying, okay, that's a reason that's a reason that doesn't look, facially wrong under Batson or whatever.
Yeah, no, I agree with you that his inquiry or his analysis seemed very much like a step 2 analysis, which was to say, the reason you have given is a race neutral reason. He says, I think I accept it. And then
So is your
moves on.
view that he never got to step 3 at all, or the step 3 analysis was, flawed?
I think the step 3 analysis was flawed. I think he goes on to say that he accepts the reason. It's a little hard to know what he's doing, but I do think he finds that there's no Batson violation. So he purports to be applying step 3, although I agree with you that he does it wrong. He doesn't do what step 3 requires of him. And he seems
So if that's a step 3 analysis and the judge is saying he accepts, which has this weird kind of credibility angle to it that I tend to view more along the lines of step 2, what level of certainty or confidence or anything do you think the judge should have that something is motivated, which raises a separate set of questions, but something that discrimination is afoot?
Yeah, I mean, we think that analysis at step 3, it's really a preponderance standard. If they believe by a preponderance of the evidence that it's motivated, that's what the judge is looking at. And, we get that from Johnson, which was a step 1 case, but it sort of talks about what sort of the ultimate inquiry is. But I think the important thing is, the judge, in determining whether or not race was a factor, was it race-based, right? I think that's the ultimate question of step 3. What the Supreme Court has said is the trial judge must determine whether the prosecutor's proffered reasons are the actual reasons or whether the proffered reasons are pretextual and the prosecutor instead exercised peremptory strikes on the basis of race. I mean, that is what the judge is should be trying to sort out at step 3, and they can
But
only do
leads
that.
me- I mean, I one of the things that I've been sort of mulling over is, if we agree that the inquiry were inadequate, either because it never advanced beyond step 2 or because it was a deficient step 3 analysis. So, what could this court sitting on BANC do to be sort of more prescriptive, to help trial judges understand what their role is? And, you could imagine, imposing a checklist of things, consider these things. And you've already mentioned, you could slow this down. You could, actually have something that looks more like an actual hearing rather than a bench conference. But there is the practical concern that I think Judge Schenker already mentioned of, you've got 30 qualified jurors, citizens who are waiting. And so then that leads me to wonder sort of how hard should the judge have to probe? And if the standard is really sort of just a preponderance, is it more likely than not under the circumstances that, race is an impermissible consideration in the exercise of this peremptory? How hard should this be? So that's one, if we're weighing our constitutional interest in a jury that is not infected by bias and, a statutory right to exercise peremptories, seems like the constitutional interest should win out, and it shouldn't be that hard to figure this out, and that things could move faster, but sort of erring on the side of kind of rejecting peremptories that don't quite pass muster.
Yes, I agree with that. And I think that's what I think that's consistent with what the Supreme Court has been saying in each case, as it's given a little bit more clarity on what is required at step 3. To your point about,
But they've never really talked about this preponderance of the evidence standard other than in Johnson, right?
yes,
Where they are really talking about, I think Justice Sotomayor references it in a dissent in Davis. There's some interesting discussion of it in the Gutierrez case out of the California Supreme Court. But that hasn't really been a focus of the Supreme Court precedent to date. But I think it's a really interesting question of sort of by what measure does the court, after looking at the totality of the circumstances, have to determine that race is being used impermissibly, not because of actual, animus or prejudice by the prosecutor, but just because race is playing this impermissible role.
right. Well, I agree with you that they haven't explicitly said, but I think they've suggested sort of this preponderance standard. And I think it makes sense in this context, because what we know is that the Supreme Court has been worried that its prior cases were making the burden too hard. And this racially based strikes, which, as you said, don't have to be based on animus. It can just be somebody using race as a proxy for how a juror will vote and thinking about using it as a proxy for where the sympathies are. But what we know is the Supreme Court has been concerned that this is a problem that has persisted. It's been intractable, and they have tried to decrease, the burden to show it. And that's why they moved from Swain to Batson. And I think what you see in its step 3 cases is a court really scrutinizing, what was going on, saying you have to look at all the factors. I think it could be helpful. You were asking about, a checklist. Certainly not exhaustive, but I do think Flowers gave some, benchmarks of the types of evidence. It does have some bullet points in it where it says the types of things.
Can I press you a little
That-
bit on Flowers? Because I think it's illustrative of a concern that we have about the practicalities of what happens in our trials here. Flowers' decision, Justice Kavanaugh, who wrote the decision, demonstrates the extensive review that the Supreme Court did, looking back at 6 prior trials, how the peremptory challenges were used, or 6 or 5 prior trials, proceedings, reviewing every aspect of the record. I'm not sure how practical that is in a busy trial court like we have here. And one of the things that I am wondering, and why I asked about whether there might be clarifications that need to be made to our case precedent around Batson, is are there practical things that we can say that would sort of encourage, I hate to say force, but encourage more of this scrutinizing to be done in a particular way at the trial level in the first instance, so we're not left on the back end and in a situation like this where the trial was 12 years ago. And between all of the motions and other things, it's winding its way up to us on appeal now. Practically speaking, what are we left with when there is a less than rigorous review at the trial court level? And what can we do in our case law to clarify what steps would be helpful at the trial court level?
Sure. Well, I agree with you that we want judges getting this right in the first instance and doing the scrutiny in the first instance, because we don't want to be litigating these rights on appeal later, right? That's what the trial judge is supposed to prevent this racial discrimination from seeping in. I think in terms of what they should be looking at, the entire record of voir dire. I mean, that is before them, right? They sat through that voir dire. The judge leads the voir dire. The judge asks the questions. The judge is there for the whole part. So that is very clearly before. It's not reaching to, far outside, to anything else. They oversaw it, right? So they are there for that. They also, what they know about, the arguments that have been made to them about the context of the case, what they know about the case. So I don't think we're saying that a judge needs to consider things that
But we
are
already
outside of
said
their
that.
knowledge, but
In our Harris decision, we said it's a totality of the circumstances, which we've always seemed to interpret as meaning the fullness of the record that is available to and the facts that are available to the trial judge. Is there more that needs to be said to clarify that?
yeah, I think the thing that has happened in the case law is that there has been this sense in the case law that if a case is racially charged, the judges have to give this heightened scrutiny, but maybe they don't have to do it if it's not racially charged. And we think that is inconsistent with Supreme Court precedent. Snyder, which was the second step 3 case, there's no suggestion that case was racially charged. And still the Supreme Court gave a lot of scrutiny to that case. They looked at side-by-side juror comparisons. They looked to see, does the rationale given, in that case, the rationale was we're worried about, the juror's student teaching obligations. They looked to say, does this make sense in the context of the case? And they're giving that scrutiny there. And so I think a thing that may have happened is judges got the impression that only in racially charged cases did they need to give the scrutiny. So Tercio and Harris, which are the 2 cases that were reversed on that basis, were racially charged. But that's not the Supreme Court is saying that step 3 requires judges to look at all the facts and circumstances at step 3. And I think it would be helpful if this court could clarify that. I also think, it would be helpful if the court could remind judges, right, that the whole record of voir dire is before them, that they may need to take a pause, as Judge Easterly was alluding to, and the types of things that judges should be thinking about. Things they should be thinking about, they should be thinking about the statistics in the case. I mean, that's a factor in step 3.
What do you think we should do with the racially charged language that is in our cases? I mean, we're sitting on BANC, so what's your recommendation as to what we should do with that language now?
Yeah, so we think that that is a factor that weighs heavily in the totality analysis. It's a factor that makes the prima facie case stronger. It is some evidence of pretext. It weighs heavily in that analysis. It probably makes it more likely there was a Batson violation, but it is one factor in the totality analysis. And so it's important. Courts should be considering it, just as they should be considering, if rationales, are highly suspect. I know LDF is going to talk about some rationales that have historically been problematic, but it's a factor in the totality analysis that that judges need to give appropriate weight to when they are doing the analysis.
You just said something about the prima facie case, and if it's racially charged, it makes the prima facie case stronger. And I guess I'm curious, do we need to measure how strong the prima facie case is? I mean, I sort of think of, at least in the McDonnell Douglas context, it's just a threshold. You get over the threshold, the burden shifts. It's, the other side's, turn to say something. You don't quantify the level of the prima facie case. It kind of drops out, right? And we even say, once you get to the second step, we don't care about whether or not the prime. So there is this strain in some of the cases talking about, well, if the prima facie case is stronger, and I'm sort of like, I don't understand why we would care about that. I mean, maybe in this sort of broader mix of totality of the circumstances, you consider a variety of factors, but why do we care about the strength of the prima facie case?
I agree with you. I think that the standard for step 1, right, is just, it is a lower step. It's at less than a preponderance of the evidence. It just has to raise an inference of discrimination. And I agree that once you get past that step, step 3 is asking the same inquiry, right? Whether or not these were the actual reasons or whether or not they were pretextual, and the judge is looking at it in light of all the facts and circumstances. So I agree that the analysis is the same. I think that the factors can weigh heavily, right? So if they weigh heavily in that analysis, right? So if the statistics are stark, that's one factor in the totality analysis that weighs heavily, right? So it certainly weighed heavily in Flowers. But yes, the facts each case will be different. Each case will have its own totality analysis, and I think the amount of scrutiny that is given should be the same.
Can I ask you a question while we still have you? We've taken you way over your time, but you sort of juxtaposed animus with using race as a proxy, or you kind of distinguished motivation based on animus from using race as a proxy. And both of those seem conscious to me. I have a question about like whether what the determination of pretext includes unconscious motive, because, you know, there's some language in the cases that seems inconsistent. Like tertio refers to intentional or not. And there's this, in Batson itself, I think Justice Marshall's opinion refers to conscious or unconscious, but then we have references in Harris and I think tertio as well that say we're talking about purposeful discrimination. I'm probably just missing some obvious explanation for how these can be reconciled, but can you help me with that?
Yeah, sure. I mean, I think what might be helpful is to look at the most recent jurisprudence from the Supreme Court, like Flowers, where it's using it uses the terminology on the basis of race, right? The trial judge must determine whether the proffered reasons are pretextual and the prosecutor instead exercise peremptory strikes on the basis of race. That's at shoe 84. And we think on the basis of race is broad enough to include unconscious bias. I mean, I think you're right that when Batson first came out, there was less of a conversation about implicit and unconscious bias. So there was that concurrence. You know, I think there was less of an understanding, but as I read Flowers, I definitely think it is broad enough to encompass that, because something that is unconscious, if it's still on the basis of race, that is a race-based strike.
But Flowers also uses the phrasing discriminatory intent is what they're looking for. Intent definitionally pushes away the unconscious bias side. I'm not saying I disagree with you at all, but I very much share the same concern with Judge Beckwith that there's kind of confusing language throughout these. And in this case that you just cited, how do you push that away? Is it just that they were talking about something separate there? Because in this case, there was discriminatory intent and that was sufficient, but not necessary per se?
I mean, I agree with you that some of these terms are used interchangeably, and the Supreme Court has used a variety of different terms. Some of the language is a little bit outdated based on what we understand about how racial bias can work. Certainly, I think that in either case, when we're determining what happened, we're looking at inferences. We're looking at inferences as to, whether or not something was based on race. So a court, as a practical matter, is looking at the same evidence and trying to assess, whether or not the strike is based on race. So I don't know that it ultimately changes the analysis that much. And I certainly don't think it was, presented here. There isn't any suggestion that the prosecutor was acting based on unconscious bias, so therefore it's okay. I mean, certainly the government's not saying that. So I don't know that this court has to resolve it, but I agree that the Supreme Court has not squarely addressed it.
One last question, sorry. You said at the beginning of the argument that you thought that there were two paths to reversal. And I'm wondering if this court were to decide that the inquiry were inadequate, is there a reason that we would have to reach the question of whether the Batson challenge was meritorious?
I mean, you don't have to. I think you can follow the path that this court did in Tercio and Harris. But I think, the important point is that if that's the path this court takes, that the remedy is a reversal, as it was in Tercio and Harris. And there are reasons for that, which is that you can't, after the passage of time, you can't, remand and go back and try to get back in the headspace of people, 12 years ago, where memories have been tainted by all the litigation and thought that's gone into the briefing here. So I think you could take that path. I think you could just find that it was an inadequate inquiry in light of all these red flags, that the strikes were racially motivated, and reverse on that ground. You could also do what the Supreme Court has done in all four of its cases, if this court would like, and find that when all of these, indicia, and red flags of racial bias are considered together, that they, compel a conclusion that the judge's finding was clearly erroneous. We don't really have a preference. We think both get to the same place and enforce Batson.
Right, thank you, Ms. Schneider. And I know you, we gave you a little extra time, but you still have the time that you reserved for a rebuttal.
Thank you.
All right, Mr. Day, you're gonna argue second, followed by LDF. Thank you.
Thank you. May it please the court, if I may reserve 2 minutes for my rebuttal. And I'll try to focus on some of the things that were concerning the court in addressing the PDS. This case required the highest level of scrutiny.
Does
This
that
court,
mean that there's a lower level of scrutiny? I think one of the questions that is not clear, entirely clear from our case law is whether rigorous review is one level and then highest scrutiny is a second level, or whether it is one rigorous review and you look at the particular facts that you have before you.
right, I think, and my conclusion in reading the cases would be that a racially charged case triggers even higher scrutiny.
But
And
why, I guess what, we're sitting here on BANC and maybe some of our cases have suggested that, but we could clarify and go in a different direction. Well, why would we have different levels of scrutiny?
I think the 2009 case of Smith, different Smith, that was not a racially charged case. And the court just noted that a racially charged case invites skepticism of the strikes. Because we all know that.
Right, I mean, you could incorporate it into a totality of the circumstances analysis, right? But why would you alter the level of scrutiny? If you're doing an equal protection analysis and you have these three you have, the rights of the defendant, you have the rights of the jurors, and you have sort of the rights of society in having jury selection operate in an unbiased way. Why would you fiddle with the levels of scrutiny based on whether the case was racially charged?
I think because in a case that is racially charged, you can have a clearly identifiable advantage or disadvantage depending on the racial makeup of the jury. And I think there's a certain unfairness in gaming the system by striking by race.
Is it your position that in the flow chart of analysis that the first step, either in the trial court or in this court, is the case racially charged or not, and then move from there and then proceed down the analysis? Is that kind of your position? That seems contrary to what PDS is saying.
That's correct. I think
I'm sorry,
PDS,
which is correct.
it's correct that the PDS is arguing that it's part of a totality analysis, that one factor is this a racially charged case? And my position, but again, it is based upon, it's based upon 2009 Smith, also in Harris. and
Right,
those are
but
not
again,
on
so
BANC.
forget the cases
But-
for a moment
Mhm.
because we are on BANC. What's your view on what role that plays from the start of the analysis? Are we moving down two separate tracks after first determining whether the case is racially charged?
My position is it's two separate tracks. In part based
But
upon
why-
powers,
We're trying to figure out why you want us to have two different levels of scrutiny,
right?
right? I mean, why shouldn't a defendant in any case say, I don't want to have a jury, the selection of which is infected by bias, and the jurors who are showing up for their, civic duty of participating in our justice system, they don't want to be struck on the basis of race in any case, right? I don't understand, why are you advocating for this? I mean, other than perhaps you think that it benefits your client in this case, but I'm trying to understand why we would adopt a rule as an en banc court saying we're going to have two tiers of scrutiny.
Right. Well, certainly it's my job here to advocate for Mr. Smith.
I understand.
And I base it in part on language and powers in which the Supreme Court said that it is easier to establish discrimination in a racially charged case,
Well, that's-
although
all right,
that again could be one factor to consider.
So I appreciate your position. Can you just tell me what it means? How racially charged does it need to be? So let's take the same facts of this case. But instead, the victim is black instead of white, but it's still a rape in a predominantly white neighborhood. Is that racially charged enough to get your heightened scrutiny?
I'm sorry, what was the?
Which track of the scrutiny would this case get if the victim were black instead of white? I mean, that would still be racially charged in some respects. It is still occurring in it is a rape in a predominantly wealthy and white neighborhood. Crimes like that tend to get broadcast over the news and, cause tremors in rich white neighborhoods in DC in ways that they don't when they happen in other communities in DC. Is that racially charged enough to get your heightened scrutiny?
And that was with a black defendant and a black
Yes.
victim.
I think it's going to
Possibly,
lead to a lot of randomness. This rule. I think it's going to be a bright line that ends up making no sense, that you're going to get 3 different judges on every case that are going to have totally different views about whether or not that's racially charged enough to get heightened scrutiny.
Right, and trying to come up with a test that can be difficult. I mean,
Right. I mean,
obviously.
what is heightened
you-
scrutiny? Scrutiny already implies some serious consideration and examination, right? But then we're going to heighten it. What does that mean?
Right. To apply the closest possible scrutiny, the court has said in
But
tertio,
shouldn't you
but that,
already be doing that? I mean, you're scrutinizing it. You're supposed to be, conducting this sensitive inquiry. How do you do that more? Which implies that in some cases you do it less. And why would you do that?
well, I think it can affect the burden that you place, for instance, on the defense counsel, as happened here, and the obligation of the trial judge and the active role. I think it's played a part in some of the division decisions on racially charged cases, and it just triggers a higher obligation on the trial judge to do more and to scrutinize
Tell
more.
me this, does it not help your client, does it not serve them equally as well to say that, well, what we were really saying in those cases, and perhaps it was confusing, was that this is a giant red flag in the totality of the circumstances. It's not that there's a separate scrutiny, but based on the history. And there's a lot of history that I recall a few moments ago, you were telling us that, this proxy concern that folks are going to be more sympathetic to their own race. But we've even seen research like Professor Foreman's Locking Up Our Own that says even here in DC, that wasn't necessarily the case. Why doesn't it serve equally well to just say, we're acknowledging history and that is a giant red flag that we hope all judges know about in the totality of the circumstances?
It may well, and I know, I think the PDS position is we get to the same result in this case, regardless of which path we follow. And, I'm here to advocate for this case and the bigger picture. I understand the concern, I understand the confusion, even with rigorous probing. What does rigorous probing mean? A lot of these difficulties, but I mean, the courts have set forth factors to perform. For instance, side-by-side comparisons that was not done here, and the trial judge could have just stopped things. Hey, okay, wait a minute. You say you want an educated jury, but let's look through the rest of the jury list. Let's slow things down a little bit, not rush to lunch, slow things down. You can see a mismatch between the justification and the strikes. Okay, you want an educated jury because of the science. This is a consent offense. What are you talking about? Also, disparate questioning among the jurors. The government asked not a single question of any of the jurors that struck the persons of color. Apparently knew enough just by looking at them and knowing their professions.
Wait, was it disparate though?
I'm sorry?
They didn't really ask questions of anybody.
No, they did. There were,
Oh, really?
I think the PDS in their brief, they enumerate some of the questions that the government asked of the white jurors. Some clarifying questions.
I read
about
through it
what-
and I didn't notice disparate questioning, but
Yeah, they asked like,
maybe
what,
didn't scrutinize it closely
what
enough.
kind of law did were you doing? But they are in one of the, maybe a footnote, but I know it's in the PBS brief enumerating the questions they asked of the white jurors.
Mr. Day, can I ask you, does the fact that Batson exists partially to vindicate the rights of the jurors themselves mean that if after step 2, defense counsel says, throws up his or her arms and says, yeah, I don't know, sounds fishy to me, but I got nothing else for you, that the trial court then has a duty vis-a-vis the vindication of the jurors' rights to still engage in that scrutiny?
Well, that is part of it, and that's why I think in part we don't just drop the issue of the Hispanic juror and the Asian juror, because who speaks for them? And the defense counsel didn't exactly drop that issue. The defense attorney thought, well, I can make this case just based upon the Black jurors. But who speaks for these jurors? And yes, and certainly the court in Harris had a lot of language in there about the obligations of the trial judge. And in part, it is because it is a duty and obligation towards the jurors who are showing up for jury service, and they have a right to serve on a jury and not be stricken on the basis of race. And I think one thing that the court can do, and I think Judge Easterly asked this, what can we do? Kind of instructions we can give trial judges, and one is just to make the point, this is not necessarily about bigotry. Tercio, they were striking white jurors. There was, I think, a Latino man who allegedly killed a Black man, and the prosecution was striking white jurors. It's really about who you think is going to be more or less sympathetic to your case. And in the Smith 2009 case, you can see it, and that was determined not to be a racially charged case, and so it did not, in that case, trigger our scrutiny. But you look at what the trial judge said, and he said, look, this is a difficult position for me to be in. I don't know what's in the mind of the prosecutor here. And he said, I'm not going to make a Batson finding against you. This sort of feeling that if you make a Batson finding, you're really sticking it to the prosecutor, that you're calling them a bigot. And it's not necessarily about bigotry. I suppose it could be. But I think we can all know that if we're in a rushed environment, we're making rash decisions. Mr. Smith, if he could have just picked any jury he wanted, he might have ended up with a jury of just Black men. And the prosecutor, they might have wanted a jury of just white women if we're just sort of making these rash judgments. And I think these are things that can occur in an attorney's subconscious mind as well.
That's what, it struck me that when Ms. Schneider was talking, she kept on referring to a step 3 credibility finding, which strikes me as a little incongruous with the way you were describing it. So I want to get your take on that framing, because, credibility is sort of, I believe you. It strikes me that a step 3 Batson inquiry can be, I believe you, but you're wrong. Like looking at all the evidence, that's not really what was motivating you. I believe that's what was on the front of your mind, and you think that's why you made these strikes. But look at the odds. What are the odds that you strike all 6 people of color? And also these explanations that you're offering me for people not being educated enough. There are jurors who you left on who had there's no assurances that they had any education, and you left them on. So I believe you that that's what you're thinking of. I credit you, but you're wrong. So do you think step 3 is a credibility finding?
In the strictest meaning of the word, not necessarily, because again, I think Justice Breyer in Miller L2 talked about the subconscious mind and how difficult it is to probe the mind of anyone. And there is, I think, given that this is an en banc court and you can look to anything, there is a concurring opinion written in California recently that I cited in my brief, and the judge there wrote that it's not necessarily looking for discrimination per se, and it's more about a risk that we're not going to allow the system to have, a risk of racial discrimination. And this is a perfect case where you have 4 out of 4 Black persons. In the most racially charged case you can have, 4 out of 4 Black persons, the Latino man who was educated, again, and they say the best they can say about him is he didn't have the right kind of education. Smacks of pretext. And we have the just overwhelming statistical numbers in this case, that if you pick 12 out of 12 people in the district to serve on a jury and they all end up white, that's a 1 in 100,000 chance.
Was there an effort made at the time of trial to assess those statistics, or was it just a look out? And I see that all the jurors of color were struck.
Yeah.
We have the benefit of the statistics now in the briefing.
I think that you could know at the trial that just it is extremely unlikely. And I think the government in their brief, they talk about, well, if this was so important, it should have been presented. And they cite an employment discrimination case where you're going to have discovery, you're going to have designation of experts. You can't exactly have a statistical expert on standby picking a jury to see
You
if the
could
numbers
run it
don't make
through
sense.
ChatGPT.
Right, I suppose. But no, you don't have to know the exact number. No, it's highly unlikely if you're picking a jury of 12 and you're in a interracial rape case and you see the sitting jury there, 12 out of 12 white people looking back at you. That is highly unlikely and it invites skepticism. And I think Tercio is a case where they struck every white person. And the court said, that's highly suspicious. That invites skepticism, that triggers a heightened scrutiny that is unlikely to be explained by anything other than bias, whether deliberate or on the subconscious level.
Mr. Day, can I ask you the same question I asked Ms. Schneider? I'm not clear on what you're asking the court to do with respect to if the court were to agree with the arguments you make in your brief on behalf of your client. You're asking that we clarify any parts of our existing case precedent? Or are you asking that we find that steps 3 analysis wasn't done at all, that it wasn't done completely, that it was done, but it was clearly erroneous, that whatever findings may have been made? What would you like to see in a decision from this court?
Right. Well, there are two avenues in this case, and one is that the judge's finding of non-discrimination, as we use the word discrimination loosely here, was clearly erroneous. The other is that the trial judge simply did not conduct the proper inquiry. And here, and in Tercio, they talked about, look, if you make a credibility finding, if the credibility finding is not based upon a rigorous probing of the prosecutor, that it's meaningless. And that happened here. There was not a single thing in the record to back up a credibility finding other than this sense of cordiality. And you don't want to find against the prosecutor. The prosecutors offered these race neutral reasons, and then okay. But there's no real credibility determination in
There
this
wasn't
case.
really a tone of cordiality from the trial court for either lawyer, actually, right? I mean, when the government gets up and says, well, actually, I had my own Batson challenge, and the court pretty dismissively says, what, you want us to, send these people to lunch so that we can
Right.
do your Batson challenge?
I
Like,
mean,
are you kidding me? I didn't sound like the court was terribly interested in hearing from either lawyer.
Right, and there I would say that, if the defense was striking white jurors only on the basis of race, that just made everything worse, not better. And I perhaps used the wrong word. I'm more thinking of the situation like in the 2009 Smith case, just a reluctance to make that kind of finding against an attorney and thinking that it's going to somehow go on the attorney's record and accuse them of being a bigot. And I think that's something that certainly any trial judge would probably prefer to avoid.
Mr. Day, can I ask you a question on, just to get your take on something that trial counsel said during the hearing on this? And the government makes something of this, trial counsel conceding that each of the government's proffered reasons were like individually valid. What do you think that means? Does that mean like they're individually valid, but if you put them all together, that's problematic? Or is that like they're individually valid? I recognize that's a reason that only matters if it's your real reason, or, how do you see these concessions?
I think that relates to how easy it is for anyone to cite a race neutral reason. And the defense attorney was struggling with this. Okay, so he says this gentleman misunderstood the question, and without pausing the case and taking time to deliberate, to say, hey, you know what? There's a white juror. She misunderstood the exact same question. And so the defense trial attorney was just struggling with that. Look, I understand that you can cite a race neutral reason for each one, but you stack them all together. We've got a pattern here, and I don't know that he used the word statistical improbability, but that is just highly unlikely. This is just very suspicious and smacks of pretext when you are striking every single Black juror in a highly racially charged case.
So is he not saying it's a sincere reason? He's just saying it's a reason, it's a race neutral reason, but he's not offering an opinion on the sincerity of it?
I think he implied that he did not believe that they were really race neutral strikes. Just based upon the numbers in the type of case that this was. And he did make some effort also to say, look, you're talking about the employment, that they're not intelligent enough to understand this case. What are you even talking about? Her dress? I mean, he was dismissive of the reasons that they were citing as well. And just, and it's a difficult position for the trial judge to be in, but the trial judge can sit there and ask questions of the prosecutor. The defense attorney can't exactly put the prosecutor on the stand and start asking questions of the prosecutor. It's a very difficult position. I think that's why the courts have placed this in the hands of a trial judge to lead the inquiry and to be skeptical of the strikes in a racially charged case and to do the probing that's been required by Supreme Court.
All right. Was there any further questions? I know you've reserved some time for a rebuttal. Is there anything further, Mr. Day?
No, thank you.
All right, thank you very much.
Good morning and may it please the court. My name is Adam Murphy and on behalf of BANC Legal Defense Fund, I'm arguing in support of the appellant Glenn Smith. If I may, I'd like to reserve 1 minute for rebuttal.
Yes.
So I want to talk about why the justifications in this case are so suspect and the importance of the right, but I think it may be worth emphasizing it. We agree with PDS that there shouldn't be a dichotomy between heightened scrutiny and rigorous scrutiny, that a rigorous evaluation and probing inquiry are critical in every case. And I completely agree with Judge Howard's framing that it really comes down to it being a red flag. And when thinking about what a decision from an en banc court sort of instructing child judges, I don't think there is a rigid checklist per se, but I think, some of the questions that they should be asking is, does this make sense within the context of the case? Does it hold up to basic questions from the trial court? Does it stand up to other jurors? And at least addressing the primary justifications and assessing the strikes in connection with each other. And I think this case presents sort of a good example of the trial court not doing any of those things. And, so defense counsel says we have total exclusion of Black jurors, total exclusion of the jurors of color, this intelligence and clothing-based justification that was used to whitewash the jury, the lack of a basis to strike the Black alternate, and that the court should evaluate the strikes in totality rather than in isolation. And in response to that last point, the trial court quite literally on, I believe it's page 133, says no, and then proceeds to break down the strikes in isolation with each other. He says we're down to 3, we're down to 2, we're down to at most the cashier and the plumber's assistant. And that is, completely contravenes Supreme Court precedent saying that all the strikes need to be evaluated in isolation. And then the trial court didn't even address the clothing-based justification and didn't respond to any of the concerns of defense counsel. And so I think the basic rule is that when defense counsel raises a contemporaneous Batson objection and then supports the objection with points, the trial court at least needs to be responsive to those points.
Sorry to interrupt, but you just said didn't respond to the concerns of defense counsel. It's kind of a minor point, but it's a factual point. I mean, defense counsel did not contest the characterization of the clothing. And so it raises sort of a broader question of what is the trial court supposed to do at that point? And what can we read on appeal from a cold record about the absence of any challenge to that characterization, also combined with sort of this credibility notion. And so I agree that the trial court can't just say at step 3, I believe you, prosecutor, but can't the trial court say, or at least implicitly say from an absence of anything to the contrary in the record, he must have believed that this juror was wearing something disrespectful when nobody said anything to the contrary.
I don't read it from this record, Your Honor. I think Snyder in particular stands for the proposition that sort of absent the trial court not saying anything doesn't mean that the trial court agreed. And I believe in Snyder, defense counsel didn't take issue with it either. And I think if you look very closely at this transcript.
If we're just going off Judge Schenker's question, if we're talking about what the court's role is and so much of this has been described as fact finding, if a lawyer says, I'm concerned about the clothing. I think it shows disrespect to the court. Should the court then make findings about what the clothing is, or at least ask, okay, tell us what you observed the juror wearing? You know, was it a t-shirt that said, you know, some sort of expletive, you know, the courts? Or, you know, was it that, you know, the dress was too skimpy in your view? Or what was it? And then the court can look at the juror and say, I see that, I don't see that, right? Like, doesn't there need to be some sort of inquiry and then actual finding for us to then review if we're doing some sort of clear error review for facts?
I completely agree. I mean, there's no way of determining the accuracy of the claim when the trial court is not making any kind of factual finding about it. And so I think it should absolutely be, and it's very similar to the demeanor-based justifications, right? Prosecutor could cite demeanor, and there's sort of no way of knowing whether it is true, and it's just too prone to misuse. And so any sort of definition of rigorous evaluation and probing inquiry would at least require the trial judge to corroborate that the clothing was indeed disrespectful, or at least asking a question, what did you find disrespectful about this clothing? And I think especially here, when the clothing-based justification was tethered to this putative notion of disrespect that we see over and over again, right? And it's one of the reasons why it's so suspect here. As we cite in our brief, the top line justifications in the articulating Batson rationales handout says, inappropriate dress, attire may show lack of respect for the system. Number of cases showed a certain disrespect for the system. And here the prosecutor said, I thought her dress was disrespectful to the court, and her clothing I thought was disrespectful. That echo should have at least raised some requirement on the trial court to at least ask the question of, what do you think is disrespectful about it, or to make some kind of factual finding about it as well. And I think the two sort of broader principles when we're looking at rigorous scrutiny and probing evaluation is that, as you know, this court said in Tercio, when the defense counsel accuses the government of engaging in racial discrimination, that is an awfully serious thing. And once a prima facie case has been made, you're saying that there is an inference of racial discrimination. And so it has to be that the trial court needs to at least address defense counsel's concerns and ask the prosecutor sort of very basic questions.
Get to the bottom of it. And I get that. Let me take you along those lines of the clothing to pull you towards this idea of conscious versus unconscious as well. So if we were looking at the clothing and it was that the prosecutor truly believed that, you know, clothing that is not Western business attire, traditional courtroom clothing is not appropriate for them to be, is not appropriate for someone to be wearing, and that it's disrespectful for them to wear a kente cloth or a dashiki in court. If they truly believe that, and we could write that up, I think I would write that up to unconscious bias, but perhaps some conscious bias as well. And perhaps I'm conflating two things I'm asking into one here to get you to address both. This discrimination, does it have to be conscious? And what about that scenario?
Yeah, I mean, I completely agree with PDS that there's language, especially in this court's case law, that it doesn't have to be conscious. There could be unconscious bias. And I think in that particular example that Your Honor asked, it seems like it's being used as a proxy for race, which provides sort of an even further problem and would weigh very heavily into the totality of the circumstances analysis.
Well, I mean, a lot of things can serve as a proxy for race and serve as a perfectly race-neutral basis to strike somebody. You know, let's say, you know, the only things we really know about most of these jurors are where they live and their professions. And so let's say the prosecutor says, you know, this person lives in a high-crime neighborhood. I think they're more likely to be distrustful of police officers. And so they live in a high-crime neighborhood. That's why I'm striking them. In the district, that can be a pretty close proxy for race, depending on the neighborhood. Do you think that also raises sort of the specter of discrimination?
Oh, I think it absolutely does. And I think it's consistent with the court's cases that says when there is a disproportionate impact, even in a case like Hernandez, they make clear that if there's a disproportionate impact, it weighs into the totality of the circumstances analysis. And there are other cases that hold sort of more explicitly that if neighborhood is 95% Black and saying, I don't want someone from this neighborhood, or distrust of police, that should raise, to quote Judge Howard, a very bright red
So
flag.
let's focus then on the distrust of police. You think, if you're a prosecutor and you have a witness and a juror, prospective juror who says, I don't trust police. Now that might also be a pretty good proxy for race. It can map on. But you think that would also trigger heightened scrutiny, despite that being sort of the most rational basis for a prosecutor to not want that juror to be seated.
Well, for one, I think it's not about triggering heightened scrutiny, because I think rigorous scrutiny,
Sure.
yes.
But suspect. I mean,
Yes.
you would consider that a suspect, a racially suspect reason, even though, even if the record were everybody said on the record, I generally don't trust police officers. Let's assume, unlike this case, police officer credibility was key to the prosecution case. You think that would kind of be a point in favor of a Batson challenge, even though it is the most rational basis that you might strike a juror?
I think it would be a point in favor of it. And
Uh-huh.
It's a
I-
difficult hypothetical, right? Because that's a basis for a for-cause challenge. And in
That's right.
fact, the jurors were asked this and some jurors were dismissed on this basis.
That's exactly right. And so if there was actual concern about bias, you would think the prosecutor would raise it as a for-cause challenge. And I think in that case, if they raise it as a for-cause challenge, there would be sort of more credibility, saying, I just think this juror is biased. But I do think it is a point in the direction of finding a Batson violation because of its association with
Now
race.
this is another interesting question. I thought, at least in one of your briefs, you said that's actually a really bad basis for a for-cause challenge. That challenge isn't really before us because we're in the Batson prosecutor strikes land. But at least one of the briefs made the point that part of what amplified how you end up with an all-white jury in this case is partially because the trial judge struck for-cause people who expressed some distrust of police in a way that you would never strike for-cause people who express, belief in the police, that I think they're always doing the right thing. Those people tend not to be struck for cause. So I thought there was actually sort of the flavor in the briefing was you guys didn't think it was okay to strike them for cause.
Well, I don't think there was.
Okay, might not have been your
necessarily-
brief. I don't mean a collective
Yeah,
brief.
the
Somebody made a
collect-
point about
yes.
that. Okay.
Yes, and I think it really will depend on the factual circumstances of the case. I think it can be quite problematic to strike Black prospective jurors, even for cause, because they don't, they have distrust of the police. But I also think potentially not doing so could serve a basis as, when you're using a peremptory strike, it is potentially pretext. Why didn't you move for cause? And I think it ties back to this case in that if the prosecutor truly didn't think that these jurors were intelligent enough to serve, then you would think she would have moved for cause and simply did not. And I just want to spend, and I see I'm out of time, but if the court will indulge me for a moment, just a moment on why these intelligence-based justifications should raise such a red flag.
Before you do that, I had one question about a case, the Fifth Circuit en banc case that the government cites to Chamberlain v. Fisher, on the grounds that side-by-side comparisons at this level on appeal are problematic when they're not raised below. In other words, raised for the first time on appeal, and therefore may limit the government and the court's ability to some extent to help prepare the record. What is your response to that? I think it gets to some of the things we discussed with PDS counsel and with Mr. Day about, is there any role for the defense counsel to play below in these cases to help tee up the issue appropriately for the trial court and then for our appellate review?
Yeah, that Chamberlain decision is sort of an echo of what Justice Thomas says in dissent, particularly in Miller L. about the unfairness. And the Supreme Court's response to that is that prosecutors have to stand or fall with their justification. Ideally, you would have a defense counsel raising it, but I think in the heat of trial, it is a very difficult thing to do. But that is an example of where the trial court could say, prosecutor, are you aware of any similarly situated jurors, just to see what the response is like? But I think in every Supreme Court case, from Millerwell 1 through Flowers, the court is conducting a comparative juror analysis and finding it to be highly probative. And it goes back to sort of the evidence in the record versus the theories about the evidence in the record. I want to be mindful of this court's time. I think just to really emphasize the sort of importance of rigorous scrutiny in every single case is thinking about what the Supreme Court has said. The Supreme Court has emphasized that racial discrimination is odious in all respects and is particularly pernicious when it comes to the administration of justice. And even within the administration of justice, jury discrimination implicates unique historical, constitutional, and institutional concerns that inflict deep and systemic harms to the defendant on trial, to the jurors who dutifully report for jury service, to the credibility of the courts, to our commitment to a multiracial democracy and to the rule of law. And what the court has recognized is that given those harms, we often need commensurate remedies for jury discrimination that are not even available for other constitutional violations. It is a reason that striking one juror on the basis of race is one too many. It's a reason that both petite jury discrimination and grand jury discrimination constitute structural error, that not even a guilt beyond a reasonable doubt and otherwise sound process can cure its taint. It's why Congress for the last 150 years has felt compelled to pass multiple statutes on this particular issue. It is the primary evil that the 14th Amendment was designed to cure. And so it would be entirely antithetical to all of those notions, to all of those principles, to the harms and to the history, to just sort of throw up our hands and not have courts engage in the most rigorous scrutiny possible in each of these cases. Otherwise, as this court said 30 years ago in Tercio, Batson's promise of eliminating jury discrimination will be an empty one.
One last question. I think you already said this, but I just want to confirm it. It's your stance that the step 3 standard would be preponderance of the evidence?
Yes, I think that's a fair read of the cases, especially in light of Johnson. Thank you.
Thank you, counsel. Mr. Coleman?
Good morning. May it please the court, Nick Coleman for the United States. I'd like to focus this court on the question that I think is before it in this case. Did Judge Motley clearly err in crediting the government's race-neutral reasons for the challenge strikes? If this court determines that, or as the Supreme Court said in Hernandez, if, as in this case, the trial court believes the prosecutor's non-racial justification, and that finding is not clearly erroneous, that is the end of the matter.
But
In this case.
sorry to
yes,
interrupt. Isn't there a predicate question of how well he did his inquiry before we get to sort of the merits question of should he have accepted or rejected this Batson challenge?
Right. So that I do understand appellants and Amici to be raising essentially two questions. The one, one of them is clear error. The other is, I guess, essentially the procedural error point. Like, what was the procedural requirement of step 3? And I think the answer is this, that at step 3, the trial judge does have to look at the entire record. I do want to dispute one thing, which I think Amici have said, which is that we are arguing that this court should adopt Justice Thomas's approach and say that, any record that evidence that was not raised by defense counsel is off limits. We are not arguing that, okay? Obviously, that would be inconsistent with what the Supreme Court has said. But what is true is that when this court does look at the record, if there are gaps in the record, in other words, the trial court has to rule on the record before it, but if there are gaps, if there are questions that were left unanswered, and trial counsel did not raise them, those gaps inure to his detriment. And the reason why is because it was his burden below to establish purposeful discrimination.
Can I just make sure I understand? So one way, the way I understand that comment, and I just want to see if it's right, is, look, on one hand, you have a strike that is justified in part based on the disrespectful dress of a juror. We have no idea what that outfit was because nobody clarified. That description wasn't challenged. Hold that uncertainty against Mr. Smith. On the other hand, there were some comparator jurors who were not struck that Mr. Smith did not raise before the trial court. He didn't point out that there was a nanny who was left on the jury, that there was another woman who misunderstood the question about whether or not she had close friends or family members in the defense or prosecution. Those things are obvious enough from the record, so we don't need to hold that against Mr. Smith. That is something we can evaluate ourselves sort of on a de novo level. Is that the position you're articulating? Or if I've misstated it, could you correct me?
So I would quibble with it only in this sense. This court, I think, obviously, following Flowers, can look at these comparator jurors, sorry, can look at them and try to assess, unfortunately on a very cold appellate record, as the Supreme Court noted in Snyder, to try to determine just how close fit, whether they were really close fits with the jurors that the government struck. You can look at them, but when there are two permissible views of whether those jurors in fact were truly comparable, then at a minimum, the trial judge's failure, if you will, to look at them doesn't mean that you reverse, because again, it was incumbent on the defense to bring these to the fore and demand explanations or answers about them.
Counsel, that seems to collapse the merits question into the procedural question, right? I mean, I guess I'm just a little confused because.
So not quite, Your Honor.
Okay.
If I could. I do think that there is, if, we've said that, we don't think that, basically trying to say that the case is racially charged, for example, provides a sort of procedural out from the defense's burden at step 3. But I do think that a case like Harris shows there can be instances where defense counsel actually requested that the trial court do certain things. Remember in Harris, the defense actually said to the judge, I think we should look back. I actually think that the prosecutor is misstating what those jurors said. Can we go back and look at the transcript? I think that there are other jurors.
In Harris, but I
Right.
guess I'd like to just take a step back from our cases to date and acknowledge that there's a strain of the case law that talks about, the burden of persuasion still being on the defense. But then there's also this strain of the case law that talks about the trial court having an obligation. And so if you're looking at the Batson inquiry and you're saying, okay, defense makes the prima facie case, government gives the non-discriminatory reason, and then some cases have language that suggest at that point it's on the court to examine the non-discriminatory reason and decide, is that a legitimate reason? Or is this peremptory actually motivated in substantial part by discrimination, right?
Well,
and the court has to do, it seems to suggest that the trial court, just like the appellate court, has to do this independent inquiry. The independent inquiry, that's from Flowers, I believe, or Foster, sorry. I mean, at least it says that we are supposed to do an independent examination of the record. And if we're supposed to do an independent examination of the record, I don't understand why the trial court wouldn't have to do an independent examination.
So it actually,
So
the
anyway,
may
you see my point.
Yeah, so I would actually direct the court to a decision of the Ninth Circuit, which addressed this very question. It was Murray v. Shariro, it's 745 F. 3rd 984, and the discussion is on pages 1004.
What year is that case?
So that was 2014, so it is after
Right.
Miller L. It is
But
in line.
Right?
Flowers.
Prior to Flowers.
Prior to Flowers, but it is after Miller L. But if I could actually point the court to what the court said, okay? There, the defendant, just like here, said, look, we think that it was, under Miller L., the judge should have done an independent comparative juror analysis. And the fact that that wasn't done means this court should reverse. And the Ninth Circuit looked at that and said, well, look, Batson and its progeny don't specify the form of the trial court's inquiry. And the mere failure of the state court to conduct a formal comparative juror analysis is not like structural error, where if it doesn't happen, you get automatic reversal. As they pointed out in Miller-El, if that had been the Supreme Court's concern, in other words, it was just the fact that the state court hadn't done this, they wouldn't have bothered to look at the evidence. They would have just stopped right there and said, we have to reverse. But that isn't what happened. The Ninth Circuit goes on to explain, why it is often necessary for a reviewing court like this court to do the best comparative juror analysis it can on the record and see what could be gleaned, but not for the trial court. And what the Ninth Circuit says is this: when there has been a Batson challenge, trial courts are not always situated to stop the proceedings and conduct the kind of formal comparative juror analysis the court conducted in Miller-El. Often, trial courts are well situated to decide the question without conducting a formal comparative analysis, because the trial court has had access to the jury questionnaires and has been intimately involved in the jury selection process. The trial judge has a front row seat in the orchestra, making it possible for the trial court to rule quickly on spontaneous Batson challenges. Federal appellate courts are not similarly situated. From our lofty perch in the loges, where we are separated by time and distance from the proceedings, we must conduct a more formal comparative juror analysis, because it's the only means we will have for assessing the state court
And I hear that, but that just seems to get it completely backwards to me, right? Because what you're saying is the Ninth Circuit, and I certainly will go back and reread this case, is telling judges, do this quickly, do this fast, do the best that you can, but appellate courts are going to have to really do this kind of scorched earth kind of review of the record, this independent examination of all the facts. And so, no, don't front load it. Give it all to the appellate courts to deal with later, which just seems like not how we deal with important constitutional rights. That doesn't make any sense to me.
So 2 points.
And I just do want to note that this case seems to proceed not just Flowers, but also Foster. I mean, where, the Supreme Court is doing this extensive review, which I take your point, the court maybe wouldn't have been doing if it just stopped at the inquiry part. But I don't think the fact that it didn't stop at the procedural question and went on to say, and we find a Batson violation, means that the inquiry is not important, that the trial courts shouldn't do a better job in the first instance.
So 2 points. I think, first of all, if Foster or Flowers or Miller-El or any of those cases had thought that, look, the trial judge needs to be doing these points, in other words, to put out this sort of checklist. I've heard a couple of times members of the panel here asking, what sort of checklist can be prescribed to the trial judge. The Supreme Court has never done that. It has said, here are the kinds of evidence that could be looked at. I think second, and this gets to a point I think that Judge Shanker raised at the very beginning of the argument, which is to try to figure out where to put sort of, who is best situated to raise some of these points and to carry out some of these tasks. Part of the problem, again, and I'm sorry to keep harping on it, is that I have not heard from Amici or from appellant here today anything that they think that defense counsel should have done to trigger any of this. On the other hand, if what this court were to do was to take this approach, look, the entire record is available to us. You can look at that whole record and try to see, is there enough here to find clear error in the judge's crediting of the government's responses? But if defense counsel asks the trial court to do something and the trial court refuses to do it, it just brushes over it, as has happened in Harrison.
Drill down for a second into the clear error review, because this is something that really puzzles me about the cases, in particular with the more recent Supreme Court cases, which do still talk about clear error review, but then go off and do their own independent examination of the record. I just have a really hard time. I mean, can you think of any other scenario where we talk about clear error review applying to a set of facts that wasn't even presented to the trial court, wasn't before, I mean, I get Foster and Flowers confused, but in Flowers, I guess, certainly the sixth trial judge wasn't thinking about the Batson strikes in the fourth trial, right? Like, but the Supreme Court is saying we're supposed to look at this entire record and then we're looking for clear error on the part of the trial judge. And it seems like maybe we don't mean clear error review anymore, or not in the sense of like actual facts. Like, yes, you would apply clear error review to, did this juror actually say something? Was this juror actually wearing, the offensive t-shirt? That's a fact, but, maybe at the end of the day, we're doing some sort of other review. Do you
I think it's
have
just-
any, can you illuminate for me or
Okay.
explain to me? Do you see
Sure.
my confusion?
I don't think that the Supreme Court was calling for a clear error review of any difference from what has always been done. Let me give you an alternative example. This court, in doing sufficiency of the evidence review, will look at the entire trial record. And it might well be the case that the defense, when it was making its arguments in closing, never noticed that the government failed to present evidence that was crucial to make a finding as to an element of the offense. Just didn't point it out. No one notices it. The trial court doesn't see it. But then on appellate review, the appellate counsel looks and says, you know what? The government didn't present evidence of that element. And this court looks at the record and says, you're right. This court would say it was clear error for the trial judge to have failed to find that element. I think clear error
We say
implies the
that-
entire
But
record.
that's a legal determination. I mean,
So is
I thought we were
this.
talking, this is a legal determination.
Well, it's
I mean, that's
both.
kind of my
It's a
question.
sense, well, right, it's a legal explanation, finding in this sense, both in the sense like, what are the facts? And then do those facts establish essentially the equal protection violation?
Okay, this is very helpful because I mean, I sort of feel like everyone's sort of talking about this as just a pure fact question, but if
Well,
you're
so
agreeing that it's
let's-
a mixed question of
I-
law and fact, that's
I want to
very
make sure
helpful.
I don't misspeak or mislead the court here. The finding is a credibility finding as to whether or not the prosecutor's reasons were genuine. Not
But-
necessarily
but-
whether they were accurate, but
but
whether they
we've
were
been-
genuine.
We've been talking about this, I'm sorry to interrupt you, but we've been talking about this with other counsel. By what measure, right? I mean, do you agree that it's, that it's sort of by preponderance of the evidence that
That seems to be the best reading of the Supreme Court cases. Again, this is where we have to ask though, who has the burden of showing that? And the burden was on the opponent of the strike of making that showing. So, I mean, that's higher than, for example, if we're doing a Strickland analysis, a reasonable likelihood of a different outcome, that's lower than preponderance, this court and the Supreme Court have said. So it's still a burden. I think to get back, again.
Before you go further,
when
I
I
want
was-
to ask
sorry.
you seem to have this dichotomy of the defense and the prosecution, but you've got a third party here, right? Flowers repeatedly acknowledges the jurors' constitutional rights too, and that discrimination isn't there. Don't you think that that plays into some of these concerns about where that burden is and how proactive the judge should be? Because
Right.
to use a phrase one of your opposing counsel used, who speaks for the jury?
So, again, I think the reality is, of course, jurors themselves can't raise their own Batson challenges in the middle. That is something that is only raised by a party to the case. So for all intents and purposes, the party who is sort of adopting the side of the juror is the party that is opposing the strike. That's just how Batson assigns the role and says that's where the burden lies of showing it. The burden doesn't become on the trial judge to sort of become kind of like an inquisitor. We have an adversarial system where we have parties that make opposing arguments and the judge is the neutral arbiter who has to decide between those
Don't you
two.
think that plays into language like rigorously probe from our Harris case?
So I think rigorous probing and et cetera, like, I think, and I think I agree with Amici on this point, it is going to depend on the facts of the case as to what the judge has to do. And that's why, again, I think, I hate to say this, but I don't think that there's any particular checklist that this court can prescribe that won't immediately seem both under and over inclusive. It will basically prescribe steps that don't seem important in some cases at all. But on the other hand, won't account for various arguments or facts or things that the parties will think were important later on. And so I just don't know that that test is going to be helpful.
What's wrong with saying at the most basic level, at least do a comparator analysis? You know, if you've got a prima facie case of a race-based strike and the justification is, well, we thought these jurors didn't have good enough education and one of them misunderstood a question. You know, what's wrong with putting the onus on the judge to say, well, what about this juror who also misunderstood the question? And by the way, there's no indication that she has anything approaching a college degree. She works for a nonprofit teaching students at some level to read, and you didn't probe her education. I mean, why shouldn't we make a trial judge do that bare comparator analysis? And if they do it, why doesn't this Batson claim succeed here?
Here's why I think you can't just sort of allocate the responsibility on the judge, which I think ultimately, as the Fifth Circuit pointed out in Chamberlain, as a practical matter, would make it the role of the proponent, basically the one making the strike, which in this case would be the government. In order to cover the record, you'd have to go through almost every juror on there, and you'd have to give your reasons as to every juror. Batson doesn't say that you have to give reasons as to unstruck jurors, just in the abstract, but it has to be done. But if this court is to ask, because I hate to say this, but if I look at a list of 36 people, and if I'm the opponent of a strike, I'm trying to bring a Batson challenge, and then I'm coming up on appeal, I can probably think of various things that the judge could have asked about, or ways in which, I mean, that's why I think we, as we've described in the brief, we have a fundamentally different view of whether a nanny is really like a plumber's assistant or a cashier. We just don't see it that way. And we don't think the government saw it that way. And we don't think that the judge should necessarily have seen it that way. The defense is now raising it on appeal when it's too late to do any of this stuff.
But I mean, let's talk about the facts of this case and what actually happened. I mean, the implication is that once the government came forward with race neutral reasons, that defense counsel sort of said, yeah, I fold. I mean, I'm not saying you're saying that, and I'm not saying your brief said that, but that's kind of being what's suggested, and that's not what happened. I think obviously defense counsel could have said a lot more, and perhaps we wouldn't be here, but defense counsel did say, you've got to look at the totality. You've got to look at the totality, and tried multiple times to say that. And the trial court, I think incorrectly on the law, we can all agree, said, no, I don't. I mean, maybe you disagree with that.
I don't read that as being what Judge Motley did, but please.
Well, so he said no, and then he cut off defense counsel, and then he said, he seemed to understand the argument about totality as suggesting that the composition of the jury had to be such, a certain composition. And that's a different argument, and I don't think that's what defense counsel was suggesting, and I don't think that's what Batson even gets at. Batson doesn't talk about the actual composition of the jury. So once trial counsel said no to looking at the totality, I think in this case, we have a situation where defense counsel was kind of, yes, could have said more, but I'm not sure it was really realistic on this record.
Well, I'm not sure when you say not realistic, couldn't have asked for a comparative juror analysis, or couldn't have said, please look at the transcript?
Well, I mean, could have, yes, but in the.
I mean, Harris, the defense counsel did that. I hate to invoke the slippery slope, but I think it is a slippery slope to essentially say that defense counsel can just wait until after the verdict to try to decide whether or not to ask for various steps to be taken. And that's exactly what happens.
That seems to be what the government is arguing that we should do. I mean, if you were analogizing this to a sufficiency case and saying, well, we can bring this up on appeal, instead of requiring the trial court to do an inquiry in real time, isn't that what you're arguing for?
No, again, these are two different things we're talking about. Again, let's talk about whether or not we have sort of this procedural error claim. In other words, what the Ninth Circuit called sort of a structural error, right? It's kind of like a structural error. The judge didn't jump through these hoops.
Right.
Therefore, reverse. And then there's the question of, was there clear error?
Right, and I'm still.
Okay, those are two different things.
I'm still focused on the procedural error.
Right, and I understand.
What it means for the trial judge. I mean, I just want to read from Flowers, right? That the court in Flowers says, as the Batson court itself recognized, the job of enforcing Batson rests first and foremost with trial judges. Trial judges possess the primary responsibility to enforce Batson and prevent racial discrimination from seeping into the jury selection process. And so
Right.
if that is what the Supreme Court said, then at step 3, you know, if the defense makes its prima facie case and the government comes back with its non-discriminatory reason, then it seems like at step 3, the trial judge per Flowers, per Foster, per Miller L, per Snyder has this robust role to play in figuring out what is the validity of this reason? Is it possible that there is some bias at play? Is it at least more likely than not that there is?
So right after the language that you cited from Flowers, the Supreme Court goes on to say, talking about the job of enforcing Batson. The trial court must consider the prosecutor's race-neutral explanations in light of all the relevant facts and circumstances and in light of the arguments of the parties. The trial judge's assessment of the prosecutor's credibility is often important. The trial judge must determine whether the prosecutor's proffered reasons are pretextual. Nowhere in there did the
certainly in
Supreme Court
light-
say.
In light of the arguments made of, I mean, you can't ignore the defense, but no way was the defense lawyer in Flowers talking about what happened at the 3rd and 4th trial.
He didn't have to. And again, this is why, again, it depends on what the record is that comes before the appellate court. In Flowers, in Miller L, in Foster, if you look at the amount of evidence that was already there in terms of disparate questioning of jurors, the use of the jury shuffle on multiple occasions, I believe it's in Foster that the defendant has obtained the actual notes from the prosecutor, which showed actual notations in which the prosecutors were actually identifying Black jury members and clearly singling them out for strikes. That record was there. And yes, at that point, the Supreme Court felt like it could make the finding clear error. One of the important things I think to note, when the Supreme Court has decided these cases, it has decided them based on, was clear error shown? What they said was there clear error? And Hernandez, the Supreme Court said, well, no, because there were two permissible views.
I mean,
of
it
the
just, again, I
strikes.
get back to that. It seems very odd to say the trial judge clearly erred because it didn't consider the prosecutor's notes that it didn't even have access to and weren't even, revealed until discovery in habeas.
So, again, when this court conducts plain error review, regardless, even in
You're talking
constitutional
in
error
the-
type
in the
cases.
Olano sense.
Right, when that happens, no one has raised any objection at all to something, right? So it was so the issue was never even put before the court. And yet, this court, like courts everywhere, will review it for plain error. But one of the restrictions on that, of course, is that the burden, is now on the defendant raising the plain error claim to establish the obvious error and to establish prejudice. One, I think, exercise to conduct here. Suppose tomorrow, Mr. Smith was to say, you know what? I actually do think that my trial counsel probably should have done more. And so I'm going to go out and file a 23-110 motion alleging that he was ineffective for doing that. It wouldn't be enough for him just to come to the trial judge and say, look, my counsel didn't ask these questions. He didn't demand a comparative juror analysis. He didn't do these things. Full stop. Therefore, reverse. No, he would have to show under the Strickland analysis that there would have been a likelihood of a different outcome. He would have had to show that, well, what would the comparative jury analysis have done? What would those questions have been? And if the answer is, looking at the record, we don't know, because the record was too undeveloped, he might not even get a hearing, but even if he got a hearing, he wouldn't be able to go further than that.
Right.
Coleman, can I press you a little bit on, you talk about this notion of the burden being on the defendant. I want to talk a little more about what burden. I mean, because normally in a typical case, the burden is on the defendant, and we don't raise issues to tee them up for the trial judge so that we have a full record on appeal when we're looking at it. And we don't typically deal with matters on appeal that haven't been raised in the trial court. But it seems like we've carved out some exceptions and made some important distinctions when we're talking about BANC challenges, which deal with the equal protection clause. So if we say the burden's on the defendant to say what's wrong with the juror's dress that the government challenged, whose rights is the defense counsel protecting? Is he looking at the broader purpose of the equal protection to also guard against the juror's right to be seated without racial bias, or society's right to have jury trials that are fair and free of bias? Or are you talking about his burden only to look out for his client? And if he's only looking out for his client's rights, what do we do with that other part of the equal protection clause, the broader rights that it's supposed to guard against when we talk about BANC challenges?
So-
Does that then fall to the trial judge? Are you saying the
Well-
trial judge has no burden, a different burden, or only a burden after defense counsel acts to do something to make a record?
So I don't think, again, I think it's hard to talk about trial judges having sort of a burden of producing evidence, which is
No, burden of
literally
inquiry.
what we're talking about here. But
Burden of rigorous scrutiny.
right, to scrutinize what's being put in front of the court, okay? What's there? And to ask questions about it, but then to come to a conclusion. I mean, they have to make a decision one way or the other based on what's being presented to them. Now, judges can, of course, ask more questions. And I think, I believe it was PDS pointed out that there are cases where this court has said it's okay for judges to ask questions, for example, in trials or whatever, or during fact-finding proceedings. And that's totally true. We're not saying that like Judge Motley couldn't. It would have been improper for him to ask more questions if he had wanted to. But the question is, each judge, I think, like in the moment there with the record before them, has to make a determination of how far to go. But to answer the more important part of your question, I think, the Supreme Court has been pretty clear that, all of those rights are sort of at play. There is the right of the defendant, not to have racial discrimination affect the trial that he's in. And there is the right of the jurors not to be discriminated against and to be, barred from jury service on the basis of their race. And there is society's interest in keeping, in basically making sure that the administration of justice is done in a racially neutral manner. And, we believe all three of those are extremely important. But there's a question of how are they enforced? Batson is one way in which it is enforced, but it is pretty clear about what the respective roles of the parties are. It has its burden shifting system, step 1, step 2, step 3, but it says that, the Supreme Court has been very clear over and over, all the way up, through Flowers, of saying that the burden is on the opponent of the strike to show purposeful discrimination. We don't think that burden was met. We definitely say that burden was not met here.
So at
And-
the end of the day,
yes.
is it your position that after step 2, government comes forward with race neutral reasons, it's sufficient in a standard case, let's take ourselves out of this case, for the trial court to simply say, okay, I believe you, move on?
So not quite, because I think you still have to give both sides, in particular, you have to give the defendant who does have the burden, the chance to show why the government's reasons might be wrong. And I take your
How would the
point.
defendant do
I'm sorry,
that?
Ron.
How would the defendant do that in trial? Cross-examine the prosecutor?
So this is why I think Harris, came to the conclusion that it did, because you're right. I agree with Mr. Day that, the defense attorney can't directly question the prosecutor. And it's also the case that right there, because there isn't a transcript yet. The defendant can't say, Okay, I'm looking at the transcript right now. He's going to have to say, let's go back and take a look at it, or maybe we have to take more time. In Harris, however, the defendant did that. He asked for those things. He said, in fact, I disagree with those. I think these are wrong. I think we should compare these jurors. And the error of the trial court, and the reason why this court reversed, was that the trial judge basically refused to take those steps. That then yes, there are now huge gaps in the record, but the defendant at least tried to fill them. And this, I think, gets back again, to the question about where should the incentives be, Judge Shanker? And I think that you have to make sure, yes, you do want to give the trial judge every incentive to make sure that the defendant gets the chance to make the record. So when the trial judge shuts off inquiry and just says, I just believe that this prosecutor, that's it, I don't want to hear anymore, nothing else. And I'm not going to take these steps. I'm not going to slow this down to go check the transcript. I don't think we need to be doing a comparative juror analysis. That could be the kind of procedural error that warrants reversal.
I mean, what about, in terms of the defense carrying their burden, I mean, what's wrong with what defense counsel tried to do here, which is all 6 of the people of color on this jury were struck by the prosecution, and gee, what are the freaking odds of that happening without a race-based justification for their strikes? And it turns out the odds are astronomically high. There's just no way that's happening. So, and the judge was pretty incredulous about that reasoning. I think this is the part of the transcript that LDF was pointing to at page 133, where he says, no, you're looking at, don't do that. Don't look at the entire composition of the juror. Let's go one by one. But looking at the stats would seem to, trigger the most extraordinary type of scrutiny of, it is very likely that these strikes in some number were based on race, based on the stats alone. So let's figure out if there's really some other explanation that can withstand a little bit of scrutiny that the trial judge didn't seem to want to apply.
So I think part of the problem, first of all, to talk about stats just in this case. I'm not a mathematician, but I certainly would agree that if the only question you were asking was, if you blindfolded somebody and said, pick 6 people, would it have been these 6? And yes, the odds are slow. But as I think the Fifth Circuit has pointed out in looking at some of these statistical analyses, that you only get to that point by refusing to control for other factors. So for example, in this case, if you were to ask, well, who has blue collar type professions as well, the numbers are going to look a lot different. In fact, they
Right, no,
will
but
overlap.
that seems like you're
Right.
starting to talk about a comparative analysis then. And if
Well-
you're going to do that, then
well,
suddenly
that's
you get
not-
into, well, why is the nanny still on the jury?
That-
Why is the nonprofit worker who teaches reading still on the jury? And why did you try to strike the IT analyst who happened to be a person of color, if that's your explanation? And the trial judge doesn't do any of that either.
So again, that isn't a comparative analysis, I would say.
Huh.
When the government is providing the other reasons, I mean, again, this court has been very clear, as has the Supreme Court, that those numbers can definitely establish a prima facie case. I mean, this isn't unique to the Batson claim. This is something that comes out of all equal protection.
But could we just
Type
pause?
analyses.
Because the other reason for striking the person of color who did seem to have some education was one that was factually incorrect, that it would have bumped up somebody else into his seat. When in fact, it would have bumped a barista into his seat, somebody without any education.
Well, that's not quite correct. She was actually a retired lifetime bookkeeper for a medical office.
A bookkeeper. It doesn't sound like a high,
But somebody who had to deal a lot with numbers, okay? Again, probably a lot more numbers and probably would have been able to understand these statistics better than I would. I think part of the problem that we've explained why we think that error happened, and we would note that defense counsel didn't see that error, nor did the judge. It wasn't even raised before the panel in this case. It was only discovered when we were in the en banc stage. The reality is the reason why we think that the best reading of the record, that error occurred because the prosecutors were off by 1. And
But
you could
sorry,
see
that-
why that would be the case.
But does that matter? Because we're talking about the juror that was tried to be struck, not the juror that was tried to be put in their place. And isn't it true? I mean, I might be wrong. I mean, juror selection is handled differently in every court, but the government could have struck any juror to place the replacement juror, whichever one it was, the barista or the other one, in the box. but it chose to strike 721. So
So
that's the
I'm-
question, right? Why strike 721 instead of any number of the other jurors?
I'm not actually sure if that's the case, because if you go back to the very beginning of the process, the trial judge had a different system than what eventually was used, which is that he identified the first two boxes, seats 1 and seats 2 as being the alternate seats, and said that basically people would go back and fill that. So that actually, the government thought that that was just its alternate strike. It did not realize, in fact, that by striking that person, it would be moving somebody up into the jury box. That was only revealed when it was later determined that for whatever reason, whether it was the judge or the clerk, the system had changed. And people were not being moved into the box in the way that the judge at least thought. Now, whether that was a miscommunication between the judge and the clerk, I don't know. But I think if you look at the entire record, and again, I don't want to go over in detail what we described in the brief, but it's the kind of error that I think is very easy to make. And I don't think it's the case that because, again, this was an alternate strike, that the government, in fact, the government was not, now that I think about it, in fact, the government would not have been allowed at that point to strike into the jury box. You only get to strike the alternates. So the only people that could have been struck were the people in seats 1 or seats 2. That's it. So we're not talking about like that the government could have been able to strike anywhere else in the box.
But
That's just a.
it could have struck the other.
Again, like
Yeah.
there can be all kinds of reasons why a prosecutor would prefer one juror over another. And when the defense doesn't raise that, doesn't say, well, why that juror, not the other, then the government never gets the chance to explain why. And, a lot of federal appellate courts in addressing that kind of question have
here-
said that that's a problem.
Counsel, here, it's not that the government didn't get the chance to explain why, it's that the government, sort of at the court's urging, said, never mind, we won't strike that person.
And I don't read the record that way. And in fact, that's how defense counsel tried to argue it. And the trial judge actually said, no, that's not correct. They didn't say that it was based on race. That's not the reason they withdrew it. They said it was because they wanted to get a different juror, but they've withdrawn it. I don't read that as being a concession by the government at all, that was an improper strike. What I read that as is this was a strike of an alternate, and the government wanted to narrow the focus of the number of issues that had to be discussed. Now, obviously, because we're talking about it today, that may have been a vain hope, but I don't think that establishes that the government's reasons were not genuine.
Would you agree that, I know your point is that defense counsel didn't raise this issue, but if defense counsel had said, what about 721? Is it your position that the court couldn't have considered that at step 3 because the strike was withdrawn? Or would you agree that that's part of the totality of circumstances? at that point?
I think all of it could have been raised. The defense could have gone back if it had wanted to and said, in fact, you know what? I realize that, I told you, Judge Motley, that I'm not going to be including the Asian and the Hispanic jurors in my challenge. But you know what? I think we should get an explanation from them because maybe it'll show something different. That doesn't happen. And so now we have this gap in the record. And, again, not to sound like a broken record, but it's the defense seems to be saying that all of those gaps are chargeable to the trial judge. The trial judge had the role of filling in any unanswered
So let me ask you,
question.
counsel, why isn't that a better policy way of looking at it? And I'll give you a long preface to go with that initial question to it. As a matter of efficiency, and we're recognizing that there is this equal protection constitutional right. And unlike the kind of McDonnell Douglas paradigm it's taken from, where you would have had discovery and you would have had an opportunity to really develop arguments and face it, we're having not a split second, but a more rushed decision without the benefit of all of that. And it seems that we really put a duty of, at a minimum, a duty of skepticism on the judge to protect this for at least 2 different reasons. One being judicial economy, because there's people hurt by this, right? If we put the burden on the appellate court to do a more thorough review, then later on, there's a whole victim that potentially has this case and resolution that they thought they have that is gone. There's defendants who may have had their rights infringed. There's jurors that may have had their rights infringed. When the trial court judge is there and has the opportunity, and in this case, it looks like could have taken an hour or 2 hours or some amount of time to really review it and not have us review it ex post facto. And there's economy concerns kind of all throughout that. Why is it not just the more effective thing to do as a matter of policy for us to put some sort of burden, which which it looks like the cases do, on the trial judge to be more proactively skeptical?
So first of all, I guess I don't read the cases as saying that the trial judges are supposed to do that. In fact, and I'm not aware of any court in the country that has said, here's a prescribed list of the things that trial judges are supposed to do. They should be conducting hour or two long hour hearings on Batson
Do you think
hearings.
there are no red flags? Like that unless the defense raises the issue, nothing can ever be a flag?
No, there can be red flags. And, again, they can be there, but a red flag doesn't mean that either at the trial court level or on appeal, that a party has met its burden of either showing in the trial court what it needed to show or establishing on appeal that the decision of the trial court was factually incorrect. I do want to address, one of the points, like, wouldn't it be better? I think it's almost always the case that if we could resolve all of these, decisions at the trial court level, so that we didn't really need an appellate court to review all of these things, or it would be much, much easier. There would be cases that would come before you where you'd know all the answers to the questions that you might have. I do think, to get back to a question I think that the Chief Judge asked at the very beginning of this.
Let me,
Yeah.
you can answer that one, but this is the question I have on my mind at this juncture. I'm not sure how you envision the three-step test under Batson working. We talk about the defendant establishing a prima facie showing of a Batson violation. Then we talk about the burden shifting to the government to provide a race-neutral explanation for why a peremptory challenge has been made. And then there's step 3, which maybe I'm mistaken, I had been thinking was where rigorous inquiry is supposed to take place. And my thought was led by the trial judge. And I think there's language in Batson that says that the trial judge has to sort of suss out how solid this race neutral explanation is. But I'm not seeing, as you described, the test and how the process should work, what role the trial judge is supposed to play in step 3 of the analysis.
So let me just.
Or step 2 for that matter.
Well, at step 2, that's probably the simplest part of it, right? That's where you hear what the reasons are. And the trial judge determines, are they literally race neutral? Okay, and we get that isn't where the process can end. Now the question becomes, what is the trial judge supposed to do? The reality is, I think it's going to depend on each case.
Right, in this case,
what would
what
happen?
was the trial, did a trial, in your view, did the trial judge do anything under the step 3 of the analysis? Did they do some limited things under step 3? Or was there no obligation on the trial judge to do anything under step 3, under your assessment of the facts of this case?
So I certainly think that the trial judge needs to make sure that the trial judge has to make sure that he has a basis to say, one way or the other, do I credit what the government is saying, or whoever is asking for the peremptory strike? Because this will apply in civil cases as well. But do I credit it or do I not credit it? So the judge does have to, determine based on the demeanor of the attorney in front of.
Here, I think I'm in agreement to some extent that the trial judge has to assess and credit, but I don't see where that happened here in step 3. I don't see where he credited or assessed anything with the juror where the peremptory challenge was withdrawn. That he makes some commentary about one of the jurors based on the challenge that juror didn't seem to understand the question that was answered. But he basically just said, I agree with the prosecutor on that. Then there are 2 jurors that he says nothing about.
Right. So
And
those
so
are profession-based
what are we
strikes.
left with when we're supposed to do the totality? Does he have an obligation to inquire with respect to each of the jurors where peremptory challenge is being made? Or Are you suggesting that the
Well-
defense counsel had some duty to question or raise questions about the four jurors? I'm just trying to understand.
I think
How it's working in your-
again, it does depend in large part on what it is that the prosecutor is saying are the reasons. Hernandez, I think, from the Supreme Court is a good example where you have a very controversial reason given, namely the concern of the prosecutor that Spanish-speaking jurors will focus on the witness testifying in Spanish and not the translator. And obviously, that was very controversial. It goes all the way to the Supreme Court, but the Supreme Court said, look, the trial judge listened to the prosecutor and determined, I credit the prosecutor that this was not done to exclude, people who were Hispanic or even Spanish language people, but that on this basis, that was, that this was done for a racially neutral reason. And the Supreme Court said, look, if you could have two permissible views, there's no clear error. I think in this case, what did the prosecutor look to profession-based strikes? Those in general, I have to say profession-based strikes are among the most common strikes out there. Almost every attorney out there, I think, whether they work for the government or the prosecutor, is going to have profession-based strikes. And ones that you just know, it's the reason why I will never be allowed to serve on a criminal jury, okay? Once they know who I am, I'm not getting on. I'd love to be on, but it just won't happen. Same reason my police officers are not going to sit on those. It's the same reason why defense attorneys will also probably not be allowed to sit on there. It's because profession-based strikes are very common.
The idea that because of someone's profession, they're just not intelligent enough.
So I want to be sensitive here to the idea that, I get that can raise some questions that seem sort of offensive, okay? I understand that. Are people who work in blue collar professions not as intelligent? Do they not have the training, et cetera? And people can have different views on that. I think few people like to talk about that. But again, the question is not, is the reason, offensive or not? But as the Supreme Court said in JEB, profession-based strikes are permissible because it's not a suspect classification. So again, the only question that we're asking here today was, what were the profession-based strikes a cover for race, but not were they ones that the court would agree with or that everybody would agree with?
And so as Judge Deal and others have mentioned before, doesn't that just invite kind of the comparative type analysis? It feels like when I'm looking at that and saying, oh, based on these professions, these folks wouldn't be that smart versus these folks who are in potentially similar professions. It feels, and this is going to sound somewhat outrageous, like a genteel version of a literacy test for voting.
So, I certainly
Chief Justice.
acknowledge those kinds of concerns, could be present. And the judge, those can always be raised. And obviously the parties would
By
argue
who?
about them at the time,
Who
but
should they be raised by under your?
I think it should be raised by the opponent of the strike if they're going to say that. But just
So
to go
how
back to
didn't they
this
in the
case.
when
I'm sorry.
requesting an analysis of the totality of the circumstances
So
that the judge refused to do?
let me give you an example here. If instead of a nanny, what we had was a carpenter's assistant, okay? The closer and closer you get to the profession of the person being struck, then yes, it becomes more and more, what you start to see is more and more possibility for clear error. That really is the lesson of Snyder, Flowers, others. There, you had a very developed record about the reasons that were being given by the prosecution. For example, knowledge in Flowers, it was knowledge of the people involved. Well, it was a small town, and it turned out that because there had been a lot of voir dire about that, there was a very solid record that showed that explanation applied equally, if not more so, to some non-struck jurors.
So
Here,
I think
though,
that
we're
acknowledges
depending.
that pretext is a slippery concept. And I thought particularly note 15 of your brief, I thought LDF and your office did an incredible job of highlighting a number of cases where similar comparators and everything else were pretextual or weren't. Doesn't it all beg the question of, with that being so slippery, the trial judge just needs to do something to develop the record and not just leave it there and pass over it with a credibility determination?
I think the answer is that when you have that sort of ambiguity in the record, like maybe a nanny, I mean, again, I have to admit to you, like when I see nanny, and I understand you can take this as being, maybe it's because I'm interested in the case. But the reality is when I look at nanny, I don't see a profession that looks remotely similar to cashier
That's definitely true.
or,
But
Okay.
the problem is that they were using the professions as a proxy for education. You know, it wasn't that we struck him because he was a plumber's assistant, and we don't want a plumber's assistant on this case because it involves, you know, the use of pipes. It instead was, I take that profession to mean that they don't have the education necessary to understand the DNA evidence, which, PS, not super relevant to the case. And if that's the proxy, if the proxy is the plumber's assistant and the cashier probably aren't educated enough or smart enough, when the prosecution asks no questions about education or intelligence, then a nanny and somebody who works for a nonprofit in a pretty nondescript job do seem like pretty close comparators in terms of jobs that don't require a degree, seemingly.
see, I don't know that that's necessarily the case.
I don't know if it's
I think-
necessarily true,
And
but
again,
didn't you want to ask if it mattered to you, government? Like, didn't you, if you
Well-
cared about their level of education, isn't it a glaring omission that you didn't ask a single question about it, even though they have jobs that would seem to indicate they don't need a degree in the same way that a plumber's assistant probably doesn't, and a cashier and a hotel attendant probably don't?
I would say no, Your Honor. And the reason why is this, if you look at the actual facts of this case, I mean, we've pointed out all the things that we know about the nanny. Her grandfather was a judge. She had a friend in the Maryland prosecutor's office. She'd been working at her job for 4 years. A lot of
But
people
none
do
of
see
those
nannies as
things-
people who have advanced training.
None of
okay?
those things
The-
indicate that she has a college degree,
So,
right? Or even an associate's degree. And if level of education is a concern of the government, and it could be a legitimate concern. One, for the assistant secretary who showed up for jury service, one can assume that he has a higher level degree. For all the lawyers who showed up to this jury, one can assume that they've got a college degree and a JD, right? For these people, if you're concerned about the level of their education, you might need to ask. I mean, for all you know, the nanny is getting her PhD and is making some money on the side, right? But you don't know, and to use it as a proxy, it would seem like it requires some more information.
so this is the problem, I think, again, of when the defense leaves this court with nothing but a cold record, because
Well,
you're
I
assuming, Your Honor.
understand your
Go ahead,
argument
Your Honor.
there, but I just struggle with the desire to put this all on the defense in light of what the Supreme Court keeps saying, which this seems to be on the courts. And I'm just going to read from Johnson, where it says, the court said, the Batson framework is designed to produce actual answers to suspicions and inferences that discrimination may have infected the jury selection process. And I just don't understand how that sentiment can be squared with the inclination to sort of shift this all, if the defendant makes a prima facie case and then the government responds, and then it's all that the court just sits back and says, okay, defense, tell me what you got, This seems to say, no, the court has a role to figure out the answer, at least more likely than not. What is going on, right? Because there are other interests at stake, as Judge Howard has already indicated.
So again, I think part of the problem, it's 3 points. First of all, I think part of the problem is that under the analysis you're proposing, or the procedure you're proposing, the defense really doesn't have any role. There is no downside to the defense saying nothing at all. And in fact, it might be to their benefit not to raise certain points. Because if they see that the trial judge isn't asking some question, let's say, for example, they look at the nanny in this case and they say, well, there's a nanny there. Nobody seems to have noticed that. I might be able to make an argument that a nanny is similar to a plumber's assistant. I might be able to make that argument. But if I say it now, and this gets to my second point, the government might come back, because it turns out that the government is looking at things other than just profession. They are also looking at, there may be all kinds of reasons why they would say that that juror was good. Maybe they did like the fact that she had a connection to legal professionals. Maybe they would have said something about, who knows, her reading material, because this was before cell phones. Like, we don't know. But I don't want to raise that because then that takes away that one more card that I can play before the Court of Appeals. And by the way, during the 5 years of my post-conviction analysis, I'm not going to raise it there either, when it might have been timely. I mean, to follow up, Judge Howard, in this case, I mean, there were 5 years of proceedings after this in which the defendant could have raised all of this. And Tercio is a good example of a case where that happened. In fact, in Tercio, the judge had cut off the Batson inquiry, but then a whole record was made in a post-conviction, post-trial motion. That record was the basis on which this court reversed. But we're left now with a scenario where after all of that, appellant has come up only on appeal and is saying, well, look at these unanswered questions and the judge should have been asking them. Again, where that system will leave no incentive for defense counsel. And again, not to get on my high horse here, but it will apply in civil cases as well. And you could imagine situations where you could have the opposing sides in a civil case raising mutually competing Batson challenges. They don't want to develop the record too much because they want to leave those unanswered questions, because whichever way the trial goes, they know that that may be a way that they can get a new trial.
So is it your view that we need to clarify this court's current precedent in terms of to harmonize it further with the Supreme Court precedent? Are you suggesting that it's clear as it is, or as sitting as the en banc court, are there things from your perspective that would help to clarify our case law to avoid some of the things that you are expressing concerns about?
So in terms of what should be clarified, I guess. I mean, first of all, I do agree with both amici that this court should say that, whether the racially charged nature of a case is, a factor or evidence, it's not something that triggers sort of like a different kind of Batson. There's just one Batson. So I do think that it would be helpful for the court to clarify that. I also think that what the court should be describing again is this. It is ultimately on the party with the burden to create the record from which to show clear error. It is on that party, but
You
if
draw
the trial-
that particular prong from where? From Batson, language in Batson or the Supreme
Yeah,
Court cases?
that the burden, I mean, it goes, Perkett v. Elam, that the burden never shifts from the opponent of the strike. So it doesn't shift to the trial judge, it doesn't shift to the government, it stays with the proponent. However, if, as in Harris, the trial judge refuses to take steps to allow the defense or whoever's opposing the strike to make the record, that can be the kind of procedural error that merits reversal. The reason why, is not, because of some need for heightened scrutiny or whatever, but just because at that point, the trial judge was asked to make an inquiry and refused to do so. I do think that, again, this court can, as the Supreme Court has held, look to the entire record. But if it doesn't rise to the level of clear error, as it did in Flowers, as it did in Foster, as it did in Snyder, if it doesn't rise to that level, that ends the inquiry. Because at that point, this court cannot say that Judge Motley clearly erred in making his credibility finding. Without that finding, this court should affirm.
So let me ask you, counsel, if we were to disagree with you and feel that the trial court had some initiative it needed to take, whether a rigorous inquiry, a duty of schedule, et cetera, I'm sympathetic to your concern you voiced that that could allow for some strategic gaming. Would it be beneficial in your view for us to clarify that only based on what's fairly raised and is fairly evident in the record, as long as the trial court has taken some action to address concerns that we think were readily apparent? Could it be at that point everything is okay? If the defense didn't raise the challenge further, didn't clarify it further, then done?
So again, I'm not sure.
I'm not asking you to
the-
concede
the-
anything.
Well, so I'm just trying to make sure I understand the delta between your position and mine here, I guess, so that I can address it if there is.
So if I disagree with you that the trial court has no independent duty whatsoever, and I think the trial court has, this is hypothetical, some form of independent duty, the concern that you raised about that incentivizing folks not asking questions, defense not asking questions, and in civil cases, cross parties not asking questions and trying to preserve things for surprise later. If I put in, and I'm asking you what type of language may be helpful, and I was taking a venture at it, something to say that things that are fairly raised in the record, as long as the trial court has made some reasonable attempt to address those, we can't find that this was, we cut it off there to eliminate your concerns.
So I guess part of the problem that I would have with that is, again, like, what is fairly raised and by whom and from what? I think part of the problem here is that I think that isn't necessarily consistent with the concept of clear error review. The reality is, when we talk about what is the duty of the judge, the duty of the judge in every case is going to be, that's the whole point of clear error, is to address things that are clearly before it. And if it gets it wrong, because it's clear from the record that the judge got it wrong, then this court reverses. If it turns out that, the judge, I think it'd be one thing here, for example, suppose, like in this case, there had actually been a claim like, look, I've got this great statistical evidence. It's not, like, Your Honor, I'm going to clarify here. It's not just that the result is something I don't like. But in fact, I think that, what are the odds, to follow up on Judge Steele's question. Suppose they had said, what are the odds? Then one might say that at that point, Judge Motley would say, okay, well, what do you mean by that? And then if the defense says, like, look, I think I'm going to show you statistical evidence on this, and I think the government then should have to respond to that. If at the end of the day, one were to look at that record and say, you know what, we don't think that, that the judge, basically the judge refused at that point to fill in the gap that the defense was asking it to.
So then help me on this case. Why isn't it enough that every juror of color was initially going to be struck?
So again, it's not the reason why you say, like, why isn't it enough? I think that certainly establishes the prima facie case. That's your disparate impact argument. But the Supreme Court has been pretty clear that disparate impact alone isn't enough. You have to show purposeful discrimination. Now, they've been very clear
So you don't
also
think
that
unconscious bias is covered at all?
Thank you for raising that, because it was a point that I did want to address. Part of the problem is not that we're not denying that, unconscious bias can be everywhere. It can certainly affect every case. It can affect a lot of things. Again, the Supreme Court really has been asking in these cases, in the Batson analysis, was there purposeful discrimination, not was there unconscious bias. But even if we thought that there was some kind of sort of unconscious bias that might be affecting the purposeful discrimination, et cetera, that's something I think it is really hard for me to see how, on a cold record, this court, which didn't hear from the prosecutors, didn't hear how voir dire went, didn't see any of those jurors, didn't, get a sense of who they were, what their answers were, that kind of thing, would be able to say unconscious bias was actually at work here. I just don't see how this court can do that. And again, I think that is a perfectly valid thing, that if the defense wants to raise it at the time and say, I think unconscious bias might be at work here because of the fact that all 6 of these jurors have been struck, the prosecutor can respond to that and the judge can make a ruling. But when it isn't raised at all, it's hard to see why Judge Motley at that time was supposed to be thinking about unconscious bias at that point. What he's got in front of him are a bunch of explanations that, certainly are racially neutral, do not seem to be outside the bounds of what, are normal peremptory strikes and reasons for those. Meet the case where you have 2 kinds of very complicated scientific evidence, one of which is hotly contested, which is the nature of the injuries to the victim, and about which the parties have been arguing out vociferously just the day before. In light of that whole case, why it is that Judge Motley would have thought just sua sponte, let's stop everything. And even though the defense isn't asking me to, let's do a comparative juror analysis with everybody on this panel.
Counsel, sorry, I know that you've gone well over your
I
time.
know.
Now that you have agreed that racially charged is a factor in the third step, I'm a little struck by your argument that this wasn't a racially charged case. I mean, if this isn't a racially charged case, what is?
So part of the problem is, again, like when we made that argument in the brief, we were trying to respond to the argument of appellant that, look, we've checked the box of racially charged and therefore a different layer of Batson now applies. We are not denying that, like, if you look at the facts of the case, that it doesn't have a racial element to it because you do have a white victim and a black defendant. We also aren't denying that, historically, there has been a sordid history of racism in connection with rape charges. Our point was, was the fact that you have a victim and defendant of different races enough to make it so that you have a different kind of Batson apply?
Yeah, that didn't
We-
seem to be
we
the argument
denied
you
it.
made. I mean, perhaps it was.
Well, they
inarguable.
did
I
make
mean,
it-
if the
I-
argument was legal,
Yeah.
we don't go down two separate tracks. I can see that argument. The argument seemed to be that we don't have racially charged cases anymore in 2025.
So if we gave you that impression, I do apologize. We are not arguing that such cases can't exist. I think each one has to be assessed, though, on its actual facts. And I think in a case like this, one of the things I do quibble about with Amici PDS is that this case was primarily about going into jury selection. Everybody thought that this case was going to be a credibility contest between the victim and the defendant and not about science. The reality is, going into jury selection, it wasn't at all clear that appellant was going to take the stand at all, that anybody would hear any account from him. And this was all just going to be whether or not the scientific evidence corroborated what the victim was saying or not. In fact, appellant himself doesn't decide to take the stand until after he's told in the first Boyd inquiry that he wasn't going to testify. So it seems to have been a very last second decision, which seemed to have been informed. And in fact, his testimony, as far as I could tell from the post-conviction hearings, was that he made that decision because he thought that Dr. Wilkes' testimony wasn't as successful. Again, I'm just trying to remember now where that came out. But again, I think you have to look at the case on its own. We are not denying that, as this court has said, that you can have cases where, you have defendant and victim of different races, and that could bring a racial element into it. But I think each case has to be judged on its facts as to just how much weight that carries. By the way, this is again another thing that appellant's counsel at the time did not raise to Judge Motley and say, you should be thinking of this as, this is similar, this historically speaking, these historical reasons why this is highly skeptical. This is going to be a credibility contest. None of that was raised. So again, why the judge should have seen it sua sponte, I don't see that.
Mr. Coleman, thanks for indulging our many
Yeah.
questions and taking you over your time. You don't get a rebuttal, so is there anything else you would like to add very briefly before you close?
I will only say very briefly, we certainly recognize the importance of the constitutional rights involved here, not just the rights of the defendant, but also the rights of the jurors involved. We absolutely think that as a whole, yes, the court system needs to make sure that those rights are protected and vindicated. The Batson procedure is the way that the Supreme Court has asked that those be vindicated. Judge Motley, in this case, followed that procedure. He made the findings that he had to, and he did not clearly err in crediting the government's race-neutral explanations. For that reason, we would respectfully ask that this court affirm the judgment below.
Thank you. I believe, Ms. Schneider, we reserved 2 minutes for your rebuttal.
That's correct. Thank you. Just a couple of quick points we'd like to make. So this court is bound by Supreme Court precedent, and there are a couple of things that this court needs to clarify doctrinal points this court needs to clarify in order to harmonize its law with the Supreme Court. The first is that step 3 requires the trial judge to rigorously scrutinize the prosecutor's proffered race-neutral reasons in light of all record evidence, irrespective of whether trial counsel explicitly argued it. That's what the court said in Miller L. In footnote 2, when it said that the defendant needs to only raise the claim. Once that claim is raised, all of the voir dire is in evidence before the court. The Supreme Court has said that the trial judge has the duty to enforce Batson, and that to do this, it has to evaluate the rationale for each strike in light of all the evidence. It cannot do it in isolation. It has to consider the whole picture. And what that means is that in a case like this one, in evaluating the strike of a cashier or a plumber, the judge had to consider things such as the strike of the Black alternate, the strike of the Hispanic juror, for the context that they add. They had to consider the statistics.
Counsel, can you just explain to me how you reconcile that with the burden being on the defendant at step 3? Is it a question of, is it a distinction between a burden of production and a burden of persuasion?
Yeah.
That the court has to do the inquiry because the court needs to flesh out what the actual evidence is. And then at the end of the day, the defense has to make the argument to persuade the court based on the fleshed out record. Is that how we should think about it?
So we understand that the burden of persuasion, what that means, the fact that the defense has it means that if the evidence is in equipoise, that means the defense lose. But in terms of each individual step, what Johnson says is it says steps 1 and 2 govern the burden of production, as you alluded to, and who's producing evidence at those steps. So it's governing the order of proof. So
So do you think that the court has sort of a burden of production at step 3, I guess, right? Because a prima facie case, not very onerous, right? Don't have to show very much. Government comes forward with its non-discriminatory reasons, they are what they are. And then it seems like there is potentially a whole lot of work to do to sort of see, wait, what were the statistics? What is the comparative juror analysis? Can we probe, can we ask questions directly of the prosecutor? Can you explain why you didn't ask about anyone's educational credentials, right? It seems like those questions should be coming from the judge, not the defense lawyer, who shouldn't be cross-examining the government's lawyer or opposing counsel in a civil case. So that seems to be a burden of production that I don't know that I've seen in any of the Supreme Court cases has ever been attributed to the party advancing the Batson challenge. It's always been couched as a burden of persuasion.
So I think what the Supreme Court calls step 3 in Johnson is they distinguish the burdens of production, which are steps 1 and 2. And then what they call step 3 is they call it the credibility assessment stage. And what the court has said in various cases, right, is that at that credibility assessment stage, the judge has to consider all the evidence, has to do a sensitive, they say in Foster, the judge has to conduct a sensitive inquiry into such circumstantial evidence of intent as may be available. Miller L. says that the judge has to assess the plausibility of the reason in light of all the evidence with bearing on it. And then Miller L. also says that everything that is in the voir dire, in the record of voir dire, is in evidence. And I think it's important to remember that in Miller L., at step 3, that defense counsel did not advance any arguments, did not point to any facts beyond, having made the Batson claim. And I think in that case, he stood on his sort of Swain evidence, but did not point to any additional evidence. And the Supreme Court said everything that is in the voir dire is before the judge. At the same time, they're saying the judge must consider all record evidence. And so I think, they haven't called it a burden of, that the judge has a burden of production. What they have said, though, is the judge has to rigorously scrutinize the evidence, and what the evidence is what is in the voir dire. And so I think,
And
maybe it's just semantics, but.
Can you speak to the government's concern about sandbagging?
So we think that if a judge is actually doing, his or her job to rigorously scrutinize and probe, this problem that the government is concerned about isn't going to happen. The record is going to be fleshed out, but we need that pause for the judge to put on the brakes, ask the questions, do the inquiry. And then I think, you know, the concerns that the government had about, oh, the record's not going to be developed enough. Well, it will actually be more developed because the judge is doing his job at the third step. So I think that concern is sort of overblown. I actually think that if parties know that judges are going to be doing a rigorous inquiry and they know it's not going to be this rubber stamping exercise that it seems to be now, where judges are, not always, but sometimes in this case, you know, in Harris, judges seem to say, okay, that sounds facially credible. I'm gonna move on to the next one. If they know there will be an inquiry, you know, there may actually be a deterrent of, you know, effect in terms of racially based strikes. And that would be the hope. I mean, the goal here is to eradicate racial bias from jury selection altogether. And then I guess the final point, which we touched on earlier, is we're hoping that the court can clarify that step 3 requires rigorous scrutiny in all cases, you know, irrespective of whether they are racially charged. But that, of course, a case being racially charged is an important factor in that step 3 totality analysis. So just giving judges that clear guidance that every case that makes it to step 3 requires rigorous scrutiny. And if there are no further questions,
Thank you. Mr. Day?
Yes, thank you. Regarding the last question from the Chief Judge regarding sandbagging, this trial counsel was trying, this trial attorney was saying, hey, Judge, look at this, look, they've struck every person of color here. And, you know, they're citing profession, but this just doesn't make sense to me. So he was certainly trying to make an argument, and the law only requires that you fairly put the issue to the trial judge. And that's an issue was fairly put to this trial judge to trigger the judge, obligate the judge to do a rigorous inquiry. I did want to point out that the nanny, I believe, had a friend in the public defender's office. Highlights our argument more than theirs. It was the potential juror who they said they preferred when they struck the alternate, who was an educated person, but a Black man. And when asked upon it, they didn't really have a good explanation. They said, well, we just prefer the person over there with the Brown University connection. I had a friend in the prosecutor's office. Surely it was not lost on them that she was a white woman, and the person that they were not preferring was a Black man. Regarding disparate impact, I just want to point out in Batson that did come up. The court said the court must make a sensitive inquiry into all direct and circumstantial evidence of discrimination, which includes proof of disparate impact. So I think from the beginning, that has been part of an analysis into a Batson inquiry. Regarding Judge Easterly's question about clear error, I think we can have clear error at 2 points, either clear error in the judge's final decision of whether there was discrimination shown or not, but also you can have clear error with regard to whether or not the judge applied a rigorous analysis that was required. And I think that's that was the failing here. We never got the rigorous analysis, and the judge clearly erred in not doing the rigorous inquiry and probing. I also want to point out that there were several pretrial discussions in this case regarding consent. There was I think a couple discovery issues that came up, and the judge had said, well, your defense has been consent, so this shouldn't come as a surprise, this particular evidence. And the judge, even during the jury selection process, one juror was upset due to the subject nature of the case. And the judge told that juror, well, the defense here is going to be consent, and so excuse that potential juror for cause. It was not a surprise. Mr. Smith gave statements to the police when he was interrogated that he in fact had sex with the person and it was consent. And also he had told friends that it was consensual. So it was not a surprise. This was simply, the defense did make them put on the DNA evidence, but it was merely a burden of production, not a burden of proof as far as they treated it. The defense's opening argument referred to consent as the defense. Last, I've heard a number of times unconscious bias, and the government referred to that. And I think it's subconscious bias. I just note that. Thank you. there any other questions?
Thank you, Mr. Day.
Okay, thank you.
Just very, very briefly, Your Honors. I want to just point you to Justice King's dissent from the Mississippi Supreme Court in Flowers, which the US Supreme Court not only looked at favorably, but largely adopted. And it sort of speaks to some of the issues that the government was addressing. When the trial court and this court, meaning the appellate court, in robotic fashion merely say that the prosecution gave facially race-neutral reasons, which were not rebutted by the defense, both completely disregard the constitutional rights of the prospective jurors to be free from a racially discriminatory selection process. And so we just really want to emphasize the point of who speaks for the juror and just reaffirm the fact that judicial scrutiny is required in every single case. And as we've seen at LDF time and again, really since its founding and it has continued, I think there's maybe nowhere in America where racial discrimination is more widespread, tolerated, and seemingly apparent than in the selection of juries. And I think this case presents the court with an exciting opportunity to step in and interrupt that cycle. And unless there are any questions, I will sit down.
Thank you. At this time, the court will take the matter under advisement. I did want to say a special thanks to counsel for your excellent briefs, to the Public Defender Service and to Legal Defense Fund for your amicus briefs, and for all counsel for your arguments. I know they were lengthy because we had lots of questions, so we appreciate your time and thoughtful responses. So at this time, we stand adjourned.